Yes.
Item number 18, Lordship. Kindly take up after 2 weeks, Lordship. I have taken consent from the other side also, Lordship.
Why?
Lordship, in this matter, engaged counsel Mr. N.K. Das, his wife is admitted in Hyderabad, Lordship. He is in Hyderabad, Lordship.
Item 18.
18, Lordship.
I'm from the appellant side, Your Lordship.
Any objection?
No, Your Lordship, but a date may be fixed, Your Lordship.
Aspirate for by Mr.
A.S. Ali.
A.S. Ali, learned counsel appearing for the respondent husband.
Yes, Lordship.
Respondent husband, on the ground that the conducting counsel, Mr.
N.K. Das.
N.K. Das, but there are so many advocates. The matrimonial dispute, the appeal is pending since 2023. N.K. Das comes after 5-6 names below. Mr. J.I. Borbhuya is there. T. Kalita is there. Where are the other counsels?
They have withdrawn their wakalat now, Lordship.
Okay. He kola as Mr. N.K. Das. He, on a medical is out of town in relation to a medical exigency, which is not opposed by MS
K. Sharma, Your Lordship.
K. Sharma,
Yes, Lordship.
learned counsel appearing for the appellant wife, relist on such and such date.
Date may be fixed.
Okay.
24th of February.
Yes.
Obliged.
May it please your Lordship. With permission of the appellant Lordship, I have to mention item number 13, Lordship. I have some personal difficulty and I need to attend a doctor in connection of my wife's ailment, Lordship. There is some.
You are Mr.
Jed Hussain. I am
As
for
prayed
this
for
purpose.
by Mr. Jed Hussain, learned counsel appearing for the respondent husband.
No, Lordship, this is MECA.
Oh,
For the
respondent
claimant.
which is not opposed by MSP Barthakur.
Whatever is not here, Raju Goswami, I have.
Mr. R. Goswami, learned counsel appearing for the appellant, relist on such and such date
26th.
on ground of a medical.
Report, Your Lordship, I beg to mention item number 6 on the daily list. Your Lordship, this matter may be listed before any other bench.
This court cannot take it up.
Yes, sir.
Oh, okay. List the matter before any other bench without me.
Obliged.
May I please, your Lordship? Lordship, item number 7, kindly. Pardon
What
me,
happened?
I lost my Quran this morning. Kindly give me the.
It's all right. It's all right. You don't have
It's
to.
okay.
It's okay. I'm sorry for your loss. As prayed for by MS
P. Das, your Lordship.
P.
P. Das, your
Das,
Lordship.
learned counsel appearing for the petitioner, relist after
Lordship,
4 weeks.
Lordship, C is for the respondent. I am for the petitioner.
Is the-
For the respondent, which is not opposed by MS
And Chaudhary.
N. Chaudhary, learned counsel for the petitioner, Koidima. Relist after 2 weeks, 3 weeks.
Lordship, your Lordship, 13 days will
On
be.
And that date, date.
On Lordship.
All right.
2nd March, Lordship. 2nd March.
Lordship, after 4 weeks, sir. DP of
And
letter.
that date, date after 4 weeks.
Then 11 March,
Yes.
kindly Lordship. 11
Okay,
March.
okay, 11 March. Next.
Of letter, Lordship.
May it please your Lordship. I beg to mention item number 9 with the consent of the other side.
Mr. Das, you are there?
Yes,
No.
my lord. Well, otherwise, my lord, service is complete, my lord. So it can come in the admission column, my lord.
Matter may be kindly fixed after 2 weeks.
It's an order matter. You wait for a while. Let's see. Service is complete.
Yes.
And what about TCR?
Received, my lord.
Then you write heard Mr. S. Das, learned counsel appearing for the petitioner, also heard MSP Sharma, learned counsel appearing for the respondent. It appears that service is complete and the case records have been received. Let the matter be listed for
Last week, admission, my lord. Last
for
week of
admissions
February, my
on
lord.
such and such date. Yes.
February. Highly obliged.
May please, Your Lordship. I beg to mention item number 10 and 11. Would be
No, no, this is a hearing matter. You wait. You wait. Otherwise, there will be nothing in my list. You wait for some time. We will see when the matter is called. Yes.
For reference to the prohibitions, number 1.
Please, Your Lordship.
Agreeable?
Not agree.
Not agreeable. Why?
Parties are not interested, my lord.
Hmm? Heard, Mr.
H.J. Tamuli.
H.
Tamuli.
J, na?
Lordship.
J. Tamuli, learned counsel for the respondent. Also heard Mr. R. Sharma, learned counsel appearing for the appellant. Though this matter was listed today under the column for referral to the special mediation drive mediation for the nation. However, parties have not agreed, or however, the learned counsel appearing for the appellant is not agreeable for amicably settling the matter through mediation. Relist in the usual course.
Obliged.
Relist for hearing.
Item 2.
My pleasure, Lordship.
My pleasure, Lordship. We have agreed. for
Agreeable?
mediation. Yes, Lordship.
Both parties agreeable?
Yes.
Very nice. Heard MS?
K.
Huh?
KLR Yanthan.
KLR Yanthan, learned counsel appearing for the appellant. Also heard MS. M. Chaudhary, na? M. Chaudhary, learned counsel appearing for the respondent. The respondent?
Number one,
Number-
insurance company.
Number 1, stroke insurance company. The matter having been placed before this court under the column for referral to the special mediation drive mediation for the nation, comma, the learned counsels appearing for the parties having consented for placing the matter before the mediation center, let the matter be placed before the mediation center on such and such date. You provide your details, huh? Hey, last talking and that date didiba for appearance. Relist on such and such date.
Must oblige, Lordship.
Item 3.
Maybe. This matter was already listed for hearing. And I requested registry to list, but somehow it is listed in this column.
Because there is a direction from the for segregating matters which can be so perhaps this falls under that category of the matters that
No.
can be tried for settlement.
But then-
So now it is all up to you. If you want, we will place it before the mediation. You can try your luck once. If you do not want to go through that exercise, we will release it from this column and put it in the usual course. Choice is yours.
We have come against a dismissal order.
I am only asking you, you see, Mr. Counsel, these matters are already categorized. Your matter falls in that list.
Fine.
So let us not go into what is the issue involved in the writ petition. I am only asking a very simple question. Are you agreeable or not agreeable? Very well. Heard Mr. R. Sharma? A. Bhattacharya, learned counsel appearing for the, this is item number? 3. MAC appeal. Item number 3, appellant. Also heard Mr. S. Sharma, learned counsel, R. Sharma, learned counsel appearing for the respondent. Though the matter was here, Agora order to Didiba and relist.
Can it be on 24th, madam?
Given in March. Yes.
Keep on.
Obliged.
Item number 4.
Yes, Ms. Majumdar.
Case for mediation because it is a pay and recovery case. So in absence of the owner, Lordship.
Ms. Majumdar's client does not wish to go for mediation.
No, it is not split case.
You do.
Welcome for that.
You
But
do.
today is actually a fix for of the filing the objection, though it is.
No, actually, today it has come up for that, under that
Mediation.
column for referral to mediation,
So we most welcome mediation if they.
but they don't want.
It
Sure.
cannot be, it is not a fit case, Lordship, because
No,
pay and
it's
recovery.
okay, it's okay, fine.
No, Lordship, I'm addressing Lordship.
It's up to their
Pay
discretion.
and recovery, and the owner and driver has not yet appeared, Lordship. So had they been present, office note
All
dated
right.
5 to.
Heard MS RD Majumdar, Learned Counsel appearing for the appellant. Also heard Mr. R. Goswami, Learned Counsel appearing for the respondent claimant, right? Claimant. Stop. Though this matter was placed under the column for referral to the special mediation drive, mediation for the nation, before this court today. However, Learned Counsel for the appellant submits that this is not a fit case for mediation, and accordingly she has been instructed by her client. Despite Mr. Goswami's client being willing to settle the matter through mediation, however, because of the unwillingness shown by the Learned Counsel for the appellant, the matter is released from the referral list, relist. Now it will come up for what? I think services awaited.
Service is awaited, Lordship.
Relist for orders when? March? On such and such date.
Lordship, I'm sure that may be given
March.
because, is a March.
6th of
Is it-
March.
6th March.
Highly objectionable.
Supplement pages, item number 20.
It will list khatam na? Referral list. Oh, I will ask. Yes, what about you, Mr. Sharma? Yes. Heard Mr. R. Sharma, Learned Counsel appearing for the appellant. Also heard Mr. Gogoi, na? No, Mr. PP Barthakur. Sorry. Mr. PP Barthakur, Learned Counsel appearing for the respondent number 1. This matter has been listed before this court under the column so and so. Parties, Learned Counsels appearing for the parties have consented for referring the matter to the mediation. Accordingly, let the matter be placed before the mediation center on such and such date. Give your details, because some intimations may have to be given to you.
27.
Relist on such and such date.
Lordship, as per last order, I was directed to take steps for paper publication. That is number 2 and 3. I have taken this step and also filed the affidavit, Lordship.
You have filed.
Lordship.
Mr. Sharma further submits that in terms of the last court's order, paper publication has been duly taken and an affidavit of service has also been filed.
Lordship. Flag excellent.
Office note dated 9/2/26 indicates that the affidavit of paper publication is kept on record.
For admission, item number 5.
Item number?
5.
Yes, what is this?
May I please your lordship?
Yes.
The petitioner before this honorable court by registered deed of cell number 5529/96 versus land measuring 1 katha 18 leases covered by DUG number 64, old 21 new, patta number 66, 798 new. So to that effect, lordship, kindly see the document number at page.
What is the case you give me? We'll go to the details later.
Yes.
What order are you
So
against?
based on this cell deed, we had purchased 1 katha 18 leases of land. Subsequent to that, mutation was carried out. But we came to know on 11/4/2023 that the present respondent number 1 has obtained a decree regarding the same subject matter. So accordingly, he had initiated the execution proceeding during execution case number 34 of the 2019.
He has a decree in his favor.
Yes, the respondent number 1,
Respondent.
with respect to the same suit property. So coming to know about this execution proceeding, we had filed an application under order 21, rule 97/98/101.
Order 21, rule
97/98/101 CPC, lordship.
yes.
So declaring our right over the suit property, also property in question. So that proceeding was registered as Mise case number 196/2023. That is petition under order 21, rule 97. So, on motion lordship, on that petition, by the order dated 2/5/2023, the proceeding was, execution proceeding was advanced till filing of the objection by the respondent number one on 1/7/20 till 1/7/2023. But during subsistence of that stay order lordship, the present respondent number one in the execution proceeding had filed an application with a prayer to extend the time to deposit the process cost for police help lordship in the execution proceeding. So accordingly, during existence of that order, on 10/5/2023 lordship, the learned executing court had allowed the respondent number one to deposit the cost for police help in the execution proceedings.
How is that prejudicing you?
So as
The
because-
execution proceeding has not proceeded. There, the order is only for depositing the money. Where are the two orders? Just give me the two orders.
Yes.
67 and 67 is which order?
My order. lordship-
Your order.
Yes.
Read. The
That-
process of execution is kept at abeyance till
Yes.
filing of objection
Yes.
by the opposite
Fixing
party.
1/7/2023.
Huh?
Fixing
Fixing so and so.
1/7/2023 for SR and objection.
So till objection. Objection filed, not filed.
Yes, objection is filed. And
When was objection filed?
presently that proceeding is at the.
No,
state
no.
of-
When is the objection filed?
Immediately thereafter, lordship.
On 2/5. When was the objection filed? Mr. Iqbal?
I am also not aware.
Because your this order indicates the process of execution is kept at abeyance till
Kept.
filing of objection.
Kept.
That is why I'm asking, when was the
But the
objection filed?
matter is, as on today, my lord, stay because of the stay order of this.
Which is the stay order?
On stay, my lord, passed at the time of motion. my lord.
Here.
The CRP.
So that is all right. But today the matter has come up for admission,
Admission.
right? Now the valid, now they are trying to say that the order date of 2/5/2023 is a stay order, staying the execution proceedings. There's no difficulty in understanding that part. But it also says till filing of objection. Therefore, my immediate reaction is, when was the objection filed? Or is there any other order which says has been extended
Order
beyond?
has been extended by the time.
Where is that order?
On 1/7/2000.
Where is that order?
That has not been annexed, lordship.
But that would indicate that. And now, when was the other order passed? That the order that you have impugned, that is page 70, annexure 9.
Yes, lordship.
A petition is filed on behalf of praying for another date for filing police cost. Prayer is allowed. What is wrong in this order?
Because execution proceeding has already been abeyance, kept in abeyance by the learned executing court, lordship. In
The
spite of
process of execution, not the proceedings.
the deposit of police cost means the continuation of the execution proceeding, lordship.
No, but you give, I want to know the dates. Mr. Counsel, if you want an order from this court, then you please show us that order by which your the interim order of 2/5/2023 was extended. The only thing I need to find out is on 10/5/2023 whether it was extended or not. That is the only thing.
Not annexed here with the petition.
So you bring it, I'm giving you a date.
Yes.
I'll accommodate you. All right. You also find out, Mr. Iqbal, when did you file your objection? Because suppose you filed your objection prior to 10/5/2023 and there was no extension, then on 10/5/2023, you cannot say this order is bad because your stay order is very clear. It says still filing of objection unless it is extended. Now he says it has been extended, but I have nothing here to indicate that this has been extended, because in that situation there cannot be any because it doesn't say till final or till further orders, isn't it? This stay is limited till filing of objection, and admittedly objection is filed. The problem is both of you today do not know on which date this objection was filed, and you both are not armed with the order of extension if it has been extended. So I'm fixing it on another date. Heard Mr. R. Sharma, Learned Counsel for the petitioner. Also heard Mr. A. Iqbal, Learned Counsel for the respondent number 1. Mr. Sharma, by referring to the order dated 10/5/2023 passed in TEX 34 of 2019, submits that in view of the stay of the execution proceedings by the Court of Munsif number 1 Kamrup by order dated 2/5/2023 passed in Miss J number 196 of 2023 in TX 34 of 2019. The order suffers, the order is perverse and requires interference by the 227 court. On a pointed query as whether the objection has been filed in the execution in Miss J number 196 of 2023, it has been submitted that the objection has been filed. However, the date of filing the objection is not available today with the learned counsels. It appears that the stay granted by this court, by the Court of Munsif number 1 by order dated 2/5/2023 is limited only till filing of the objection by the opposite parties. Mr. Sharma, however, submits that the court has thereafter extended the stay. However, a copy of the extension of the stay is not available with him today. Relist on such and such date to enable the parties update as regards the position of the stay in the MJ case to so and so, so and so.
4 weeks, 4 weeks. After 4 weeks.
First week of March.
13 of March.
God bless.
Item number 8.
May I please bring in the.
Yes, Mr. Agarwala.
Yes, Lordship, here my case has been transferred to MCT Dhubri, Lordship. Though I am having jurisdiction, I am had the case here, Lordship.
I think the scan copy has not been received.
Received, Lordship.
Huh? TCR MAC 51 has not been received till date.
No, Lordship, that.
What has come is MAC 1597.
1597.
But the other one has not come. The office note indicates. And service also not complete.
Service, Lordship, on responder 1, 2, 3 is complete, Lordship.
No, but the others are not complete, 4 and 5.
That is
No,
mentioned
no.
that item.
No, I think 1 and 3 has 1 to 3 has been received.
Yes,
4 and 5, I think, item received.
item received also.
1 and 3 appears that the notice was delivered to the person of the appeal. 15 4 received.
My point is this, Lordship, my case should be started here, Lordship. That is stage.
Right, let this come first.
No,
It appears that though the scanned copy of the MAC case number 51 of 2024 D was called for by this court on by order dated 16/12/2025 from the Motor Accident Claims Tribunal Dhubri. However, the office note dated 17/2/2026 indicates that the TCR MAC 51/24 has not been received till date. It appears that service is complete, right?
yes, Lordship.
It further appears that though neither AD card nor unserved notice has been returned for the respondent till date. However, the postal journal, in terms of the
This one, 1, 2, 3 is delivered.
however, the postal journals procured from the dispatch section at flag X1 Part 1 file and consignment tracking details procured from the India Post website at flag X2 Part 1 file as reflected in the said office note indicates that the notice was delivered to the respondent numbers 1, 2, 3 and
4 and 5.
4 and 5 And in respect of 4 and 5, respondent number 4 and 5, it is stated that item received. Service accordingly stands complete. Relist, send reminder and relist.
Lordship, then interim is there, Lordship.
Is
Then
it,
interim should be continued.
it is already there?
Yes, Lordship. Interim is respect of.
All right, interim passed earlier shall continue till the next date of listing.
Supplementary list item number 21.
Made usual actually. My lord, this present affidavit when filed under section 23 of the Railways Act, Railway Claims Tribunal Act, my lord. My lord, the records has been called for if the matter can be fixed for hearings in this matter.
This is item number?
21.
It's for supplementary list.
Yes, my lord.
Is for orders. So service is complete?
Yes, my lord.
Hmm?
My lord,
TCR has not come till now.
TCR.
TCR? I sir? No, the office note yeah, Mr. Rathi.
Yes, my lord.
Mr. Rathi, the office note indicates no step for notice to respondent.
Lordship, is 21 to 29. Na?
21
They
to
are all
23.
similar matters. That is actually erroneously typed because that service part in the order is erroneously typed.
Erroneously or inadvertently?
Because in the first
Inadvertently or erroneously?
inadvertently.
Please mind the words. Office have prepared it. There cannot be any erroneous finding of the office. It could be inadvertent. No, but Ms. Sharma, in item, I have item 21's file. So in item 21, you have received?
All are the same.
No, could be, but I am asking a very specific question because notice has to be taken in respect of all the cases. Correct?
Yes.
Because there is an order. There is an order that issue notice to the respondent through speed post as well as through usual post. So therefore, I'm asking in MFA 8525, have you received notice? Yes or no? Just answer that. No. So it's all right. And you have received notice in the rest of the items. 22 you have received notice. And the others you have not.
But other councils had received. Other central
So they have
government
received. So and you can also appear in 21?
Yes, Lordship. Here also.
You can appear. So I will record that and I will say service is complete then. Is that all right? So however, you hand her a copy of the
Yes.
extra copy because she said she will enter appearance.
I'll do that.
So there is nothing erroneously typed in the office
Absolutely.
note because as a matter of fact, no steps was taken in item 21. You might appear in 21 that you know, office doesn't know because neither you have filed an wakalatnama in item 21 nor they have taken steps. So you as an officer of the court, kindly be mindful when you say something. I am now taking it that she is appearing. I'm recording that, Mr. Rathi, so you need not do any other steps except giving her an extra
I'm
copy.
obliged.
এবার বাকি কিটা ফাইল দেখাই দিবা মোক। In item 21, you say, heard Mr. D. Rathi, learned counsel appearing for the appellant, also heard Ms. B. Sharma, learned DY SGI.
I'm CGC. I'm
Learned-
on behalf of yes.
I will say learned CGC for the respondent. Though office note dated 9/2/26 indicates that no step for notice to respondent has yet been received. However, MSB Sharma, learned counsel, submits that since she has already received notice in a connected MFA, in a connected appeal being MFA 86 of 25, she also has instructions to appear on behalf of the respondent in the present case. In view of, but you filed your power here also. She accordingly submits that necessary power shall be filed within a period of 1 week from today. 1 week. In view of the aforesaid submission and undertaking by MSB Sharma, the service in respect of the respondent stands complete. Then you write, it appears that TCR has not yet been received. Repost on such and such date with an update as regards the TCR. Now, next case, Gita sir.
9th of March.
You fix all the dates together, huh? But let me see one.
Item 22.
Item 22 also TCR may not have come. So here also no steps only indicated, but you said you have received here, no?
My name is already appeared in the previous order. That is why I
My lord,
have said.
Central Government Council appearing for the Union of India. That's why no
I
separate.
heard ऊपर तो एक ही did and then you don't say no notice. Miss B Sharma submits that she has instructions to appear in the said matter. The TCR or কথা খিনি একেলগে কৈ পেলাই relist. Next. 23, who is appearing for the respondent? No one is appearing.
CDC is there, my lord. Union of India.
No, but she may not have instructions in this. Do you have instruction in this? She does not have instruction in this. But why are you not taking steps, Mr. Rathi? The orders of the judicial order says.
Yes.
So you take fresh.
I'll take fresh steps, my lord.
Heard Mr. D. Rathi, learned counsel appearing for the appellant. It appears that steps for notice to the respondent has not yet been taken. Mr. Rathi undertakes that the same shall be taken within the course of the day.
Yes, ma'am.
Within
I'll
the
take
course of the day. In view of the aforesaid undertaking, relist on such and such date koida. It further appears TCR hekin at koridiba. TCR part same takiba. Next.
24.
I think the same order goes here also. The last order too. He'll take steps.
55.
Are you sure? You sure you can take steps by today?
Today itself, my lord, I'll take that. I'll take it.
25 also same. A last order, huh? No steps, one item, like undertakes. Then
26.
27, my lord, until
all
26.
same.
Also.
Okay.
27.
So I'm fixing all the matters then on 9th, no? 9, but steps lule 9th or like a who? All episode date diba niki?
16.
16.
Because fresh steps, no, you're going to take it.
Yes.
So we'll have it on 16th then. Okay, all this item 21 to 27, huh, Ms. Sharma? 16. But Ms. Sharma, you file your power, huh?
Here I have number 10 and 11.
May plead your lordship.
Yes.
Matter may be kindly fixed after 7 weeks. Senior counsel BK Sharma is out of session for his eye operation.
You can argue this is an opportunity for the younger generation. You know your senior is not there today. You had an occasion to look into the brief. You're an officer of the court as well. Isn't it? You see, opportunities will not keep coming. There are so many younger members of the bar who are willing to do matters but are not getting opportunities. So when one gets it, I think you must grab it. Anyway, I shall not prejudice you today. You seem a bit reluctant today. Maybe you're not, since you have not read it. But next time, this court is not going to be accommodating you in such matters. These are old matters. When can you do it now? Tell me that.
7 weeks after 7.
No. That's a 2010 matter. Next week, I can accommodate you till next week. Either you argue or you make alternative arrangements. It cannot go on till 7 weeks.
It's 3 weeks.
That date did you march shot? Your name? Heard MSP Sharma Leonard Counsel appearing for the appellate, who submits that the conducting counsel, Mr. BK Sharma, where is he?
Hyderabad.
Is in Hyderabad due to a medical treatment. Mr. S. Sharma?
And Thakuria for Assam.
N. Thakuria.
And
Mr. N. Thakuria, learned counsel, appearing on behalf of Mr. S. Sharma, does not oppose to the prayer sought. Considering that the matter is old, is an old pending matter. However, in view of the medical grounds mentioned before this court, despite this court is adjourning, reposting the matter to such and such date, it is needless to be clarified that on that date, if Mr. Sharma is still not recovered from his medical problem, alternative arrangements for going ahead with the hearing is be taken. No further adjournment on this ground shall be given in this case. Ms. P. Sharma undertakes. Ms. P. Sharma is also, you are on record, you are not on record. You are there on record. Since there are other counsels on record, including MSP Sharma, it is expected that the matter shall be taken up with seriousness on the next date of listing. So, Ms. Sharma, you have heard it. So you start reading from today. You take guidance from your seniors also. They'll help you. Okay?
And 12.
where is the loss?
Where is the petitioner? What is this? Which is the order?
My lord, over the impute order, page 52, my lord.
Page 50?
52, my lord. Relevant purchase starts from 53, my lord. Section 6.2 of the specific relief act was filed by them. But canon.
What to do? The other side is not there.
Yes. No, so may do one thing is short date medical. I'm ready, otherwise I have not told them my lord. I'm for the response number 3, 4, and 5.
You can dismiss it for default also. But it has come after a long time.
Yes.
Last time it was fixed on 17. None appears for the petitioner on call. Heard Mr.
A children. A children.
A. Chaudhary, learned counsel, appearing for the respondent.
3, 4, and 5.
Respond number
3, 4, and
3, 4, and 5. It appears that this matter was last listed before this court on 21/7/2017. Since the matter have been listed after a lapse of several years, let registry intimate the learned counsels appearing for the petitioner through WhatsApp message or any other means as regards the next date of listing. Repost on such and such date.
And 7. All right.
Just 14.
Petitioner and also petitioner. Petitioner and or learned counsel appearing intimation. Yes. Why are you looking at Mr. Talukdar? Huh? It's all right.
Last order, passing Lok Adalat.
Last order?
Order dated 14/6/25.
Yes, pre-settlement compromise sheet has been placed on record as per which there was an agreement for payment of an additional amount of 17 lakhs. The settlement sheet was sent by The learned counsel for the claimant, learned counsel as well, so and so. The present person representing the claimants who come from eyes of ladies and children have come to the Lok Adalat all the way from Barak Valley, which is more than so and so. However, but we are approval to be on counsel from value. He is retracting, resigning from the pre-settlement, which will reach and record in my opinion on account encouraging and paying. Is the cost of 50,000 paid or not?
So I am paying 310 for.
No. You paid today or you otherwise severe consequences. This order was passed on 14/6/2025. There is a judicial order for paying 50,000. In fact, you should have, before Mr. Talukdar points out this order, you could have, with profuse apologies, brought this to the notice of the court. You are saying he does not have the file. You want him to adjourn.
What's it?
Sorry, Mr. Counsel, there is a judicial order.
What's it?
Please respect that.
What's it?
There is a judicial order directing the insurance company to pay a cost of rupees 50,000.
What's it? We put a Lok Adalat.
How much time do you need to pay this?
310.
3 weeks will not be granted. 3 days can be granted at the best. If you are agreeable to 3 days, I am passing the order. Otherwise, no, sorry. Heard Mr. M. Yeah, Mr. Talukdar, right?
No.
Sorry, KK Bhatta. KK Bhatta, learned counsel appearing for the appellant. Also heard Mr. M. Talukdar, learned counsel appearing for the respondent. Respondent number? 1,
2, 3, 4.
1 to 4 claimants. It appears that this court on 14/6/2025, after noting the conduct of the insurance company in retracting / resiling from the pre-settlement which was reached and recorded in writing between the parties, directed the insurance company involved to pay a cost of rupees 50,000 to the claimants for causing unnecessary harassment in requiring them to come to Gauhati from Barak Valley, which is more than 300 kilometers away, and attend the Lok Adalat. Ultimately, stop. Despite the aforesaid direction, the amount of the cost of rupees 50,000 is not deposited before the registry of this court. Stop. Mr. So and so request 3 days time.
What's it? I am paying.
Upon before this court depreciates the conduct of the insurance company in not complying with the direction passed by this court on 14/6/2025 and gives a stop. However, before passing adverse orders, a last chance of 3 days is given to the insurance company to comply with the direction passed earlier by this court on 14/6/2025 and pay the necessary cost as directed earlier, failing which consequences in accordance with law shall follow. Repost on such and such date. You post the matter on next Monday. No, not Monday, Friday. 3 days, Ajipra 3 days hole ketia hobo? So Monday.
Number 15.
May I please? Lord, kindly pass over the matter for the time being.
Time being.
Yes, sir. This lags on court number 4.
All right.
Item 16 and 17.
My lord.
Where is your counterpart?
16.
Oh. This is 16/17. You are there, Mr. Roy Chaudhary.
My lord, I was sorry.
Okay, call his matter. 15.
I'm sorry, my lord, I was on gigs.
No problem. There's a second appeal.
Second appeal, my lord.
Where are the substantial questions of law?
It was already admitted, I think, my lord.
No, where are they? What are the substantial questions of law?
My lord, page,
No, give me
9.
the order. Which is the order?
my lord.
14, 12, 2022.
Yes.
14, 12. Yeah. Yes.
So issue was not framed on declaration of right, title, and interest. And there was no pleading and discussion. But there was a finding about recovery of khas possession. This is your first, whether that is perverse or not. That's the first question, right?
My lord.
Second is whether the Jamabandi confers any title in favor of
The revenue
plaintiff.
record. Whether revenue record confer any title.
Whether the burden lies on. I think there is a direct decision on this.
My lord, I have some decisions. And my lord, here the case was that I have the defendants, number 2 and 3, no? 2 and 3. And the defendant number 1 and the plaintiff were brothers and sisters. They inherited the parental property. The plaintiff filed a suit saying against defendant number 1, 2, and 3, where defendant number 1 never filed a written statement, neither there was a cross-examination, anything was done. And my lord, the plaintiff case was there was, after inheritance, there was an amicable settlement, and few portion of land got by defendant number 1, and much more chunk was provided to the plaintiff. And the defendant number 1 thereafter, by trying to sell those property to 2 and 3. My whole case was there, my lord, whether in what circumstances the amicable settlement was proved by the plaintiff. That is substantial question number 3.
Under what circumstances?
The plaintiff was able to prove the amicable settlement. There was no documents, nothing was there.
Who are you?
I am the person, this defendant number 2 and 3, who are in possession, who are trying to, they are trying to evict me.
You were in possession.
Yeah, I am in possession. I'm in possession.
Of the suit land.
Suitland.
And who is the plaintiff?
Plaintiff and defendant number 1 are the brothers and sisters. Plaintiff and defendant number 1. Brothers and sisters, right? Brothers.
So they are who?
They are the brothers and sisters and inheritance of the original over the total plot of land of 14 acres.
Inheritant, heir.
Yes.
Heirs of?
The Muslimuddin, the original owner of the plot of land of total 14 acres.
Original owner.
They are,
What is your title?
title, Malat, I get it from defendant number 1.
On what basis?
Because there was a sale, Malat.
No sale agreement for sale.
Agreement to sell.
Oh, so your title, you are claiming a right through the agreement to sell. Can that be a title?
My lord, that can be used in the specific relief act for corroborating the evidence, my lord, agreement to sell. There may not, because there should be a registration, under registration section 17 will come. Otherwise, it can be used as a...
The agreement to sale is not a sale. How long are you in possession?
Since how long?
On the basis of the agreement to sale.
On the basis of quite a long time. But my whole case is that how is the plaintiff able to prove his title? Can the Jamabandi prove the title? No. Revenue records, their direct decisions from the Supreme Court, revenue records does not prove the title. How? Because the burden is 101 with the plaintiff. He has to prove his case. And defendant number was never
No, unless a contrary is brought. Otherwise, I think records will be it is not valueless.
No, man.
There was some decision I remembered. One decision which says something about the revenue records, about the evidentiary value.
Malad, what it says, Malad, that some judgments from Gauhati High Court and then Malad, from Supreme Court.
See, it is ultimately a record of right, correct?
Record.
What are an entry in the Jamabandi indicates a record of right?
No, Malad. It only indicates that paying of the mutation. Mutation does not confer title.
So here mutation was done.
Mutation was done, mutation only gives the right on part of somebody on my behalf of my friend to pay that revenue and others. And section 50 of the
You are also not, you are only claiming on the basis of an agreement to sale.
from defendant number 1.
And what is the defendant number 1's stand?
Defendant was never appeared, no written statement, but he was not allowed to give evidence because there was no written statement.
He did not appear. Did you bring him as your witness?
No, madam.
You could have
I brought him, but his evidence was not allowed because he didn't file the evidence, a written statement.
Mr. Roy Chaudhary,
My lord.
if you bring a witness, the
My-
witness doesn't need to. I understand that he needs to file a written statement if he appears in
My
the
lord.
capacity of the defendant number 1.
But
if he is appearing as your witness,
yes, and the finding
which is the order saying that he will not be allowed?
my lord, that I'm placing before lordship, my lord.
So issue otherwise is very, very, very narrow.
My lord, my lord.
The right, whether the Jamabandi entry will confer them a right.
My lord. ওই জায়গাটা কোথায় যে ওকে অ্যালাউ করবে না এভিডেন্স দিতে বলেছিল that particular point that I'm placing before lordship where it was said
মাটি দিব লাগে নেকি? অলপ টাইম লাগিব। যাব পাৰা।
Indigo Village में सकते दूसरे किधर से अपीले बच्चों से My lord, page
One second.
page 13
One
paragraph.
second. One second. Yes, Mr. Rai Chaudhary.
Your lordship, that point that your lordship has raised is at page 33, para 11.
Page 30.
3, para 11 of the appellate court judgment.
So the concurrent finding against you.
My lord. Concurrent finding. Para 11. On the above issues, plaintiff side had adduced evidence of 3 witnesses, exhibited certain documents. Evidence of plaintiff side remained without cross-examination, as right of cross-examination was forfeited due to rejection of petition for adjournment. Defendant number 2 and 3 has also adduced evidence of 3 witnesses and also exhibited some documents. They were duly cross-examined by other side. However, affidavit of defendant number 1 and DW1 was rejected as he did not file any written statement. Subsequently, defendant number 2 and 3 examined the defendant number 1 as their
So
witnesses.
it says, however, the affidavit of defendant number 1 as DW1 was rejected. Oh, that is strange. Because he can, independent of being a party, if you are producing him as your
At
witness,
DW4, he was produced as a DW4.
DW4.
4.
Yes.
The 2 and 3 examined the defendant number 1 as a witness as DW4.
Okay, let us see the judgment. Which is the trial court judgment? Let us go there first.
That starts at page, my lord, I think 12, 11.
So they only documents they are bringing is the Jamabandi
My lord.
and the mutation.
My lord, nothing.
Both otherwise by itself they don't confer any title.
And moreover, my lord, the Jamabandi, what I got it from the evidence, my lord, exhibit 3 records, there were total 58 bighas, from which there were 14 bighas belong to their father, which portion where nothing was there, no description.
These are only for fiscal matters,
Fiscal.
entries for, isn't it?
My lord.
By itself they don't. If he is claiming, then he has to show how he got it.
And moreover, amicable settlement only by placing evidence. Where was
What is the amicable settlement?
that defendant number 1 only get 1 bigha and he gets around more than 12 or 13 bighas of the total 14 bighas.
And how is that amicable settlement
No
proved?
proof, nothing.
No, but you see, amicable settlement, again, there is a decision. I don't have the decision readily. Family disputes,
That Transfer of Property Act, which says family settlement can be done
orally also.
Orally also. But and the appellate court held that I will not go into it, how it was, amicable settlement was done, the para.
Let us go one by one. I'm taking it up with an intention to dispose it of. So you place it slowly. Let us. I think the trial court will clear up most of the facts, and then you can go to the appellate and ultimately sum up your argument with law. Yes.
Definitely. But I start at page 11.
Yes.
This is a suit for declaration of right title interest and recovery of khas possession along with consequential relief. The suit was initially instituted only against defendant number 1, but subsequently defendant number 2 and 3 were also implemented. It is pertinent to mention that initially the suit was filed for declaration of right title interest and confirmation over C scheduled land, but subsequently the plaint was amended seeking recovery of khas possession and plea of forcible disposition of plaintiff from the suit land by the defendant on 29/12/2013. The facts of the plaintiff in brief are as follows. The plaintiff and defendant number 1, Abdul Sattar, are sons and daughters of late Muslimuddin, who was the original owner of land measuring 14 bighas. application to Dag number 58 and PP number 109 of Durabandi Kisam of Moirabari, Moja under Lahari Ghat, Revenue Circle, District of Morigao, Assam, which was fully described in Schedule A of the plan. Originally belonged to their predecessor in late Muslimuddin. During lifetime, he had been enjoying A schedule land by paying land revenue. On his death in the year 1997, the plaintiff and defendant stepped into his shoes, inherited his suit land, and accordingly records of rights were corrected in their names. Subsequently, they made amicable partition of A schedule land, and accordingly land measuring 1 bigha 2 kata was fallen in the share of defendant number 1, Abdul Sattar, which is described as Schedule B of the remaining 12 bigha 3 kata out of A schedule land fall within the share of plaintiff, which is described in Schedule C schedule of the plaintiff. Thus, B and C land are within A schedule land. The plaintiff have been possessing the C schedule land jointly since after amicable partition with defendant number 1, and defendant number 1 had been possessing B schedule land without any disturbance from plaintiff side. It is contended that the defendant number 1, in collusion and under the ill advice of some wicked person, made a plan to sell entire A schedule land in an order to deprive the plaintiff from C schedule land. Under such circumstances, plaintiff approached the defendant number 1 for amicable family settlement, but such approach and attempt on the part of the plaintiff were ignored by defendant number 1. Instead, he declared that he would forcibly occupy and plow the C schedule land and would sell 6 bighas of land from entire A schedule land. While possessing C schedule land of the plaintiff, the defendant number 2 and 3 forcibly enter into the suit land on 29/12/13 and disposes the plaintiff therefrom. The defendants made earth filling, constructed plinth and house by removing
So,
soil.
so under this amicable settlement, that A schedule goes to whom?
A schedule, my lord, is the whole land, and B schedule land of 1 bigha 2 kata goes to defendant number 1.
D1.
B
D1 and C goes to plaintiff.
plaintiff. And A schedule is the whole land.
Whole land.
Whole land of 14 bigha, and by the defendant number 1 gets 1 bigha 2 kata.
1 bigha 2 kata.
And whereas plaintiff gets 12 bigha 3 kata.
12 bigha
3 kata. From total 14 bighas. That itself shows that there is something. Can the brother and sister 1 bigha and 12 bighas? Then it is pleaded that the defendant number 1 has no right to enter, sorry, my lord, plead for removing the defendant. I will read from again, my lord. The defendant made earth filling and constructed plinth of the house by removing soil from the suit land, thus made the land unfit for cultivation. When the plaintiff raised protest, the defendant number 2 and 3 claimed that they had entered into an agreement with defendant number 1 to purchase the suit land. It is pleaded that the defendant number 1 has no right to enter into an agreement with defendant number 2 and 3 to sell the entire suit land, as because he had no title over the suit land. Hence, defendant number 2 and 3 are illegal possessor of the suit C schedule land. The defendant number 1 have received summons of the suit, entered appearance initially, sought time for submitting written statement, which was allowed, but subsequently he did not submit any written statement. The impeded defendant number 2 and 3 filed written statement jointly, pleading inter alia that
you are for 2 and 3.
2 and 3. Appellant herein. The impeded defendant number 2 and 3 filed written statement jointly, pleading inter alia that there is no cause of action for the suit. Suit is barred by limitation, hid by non-joinder and misjoinder of parties. They also denied the right, title, and interest of the plaintiff over C schedule land. The defendant case, as reflected under the real facts in their pleading, in brief are as follows. Late Muslimuddin had 2 wives, Adbajan and Mirjan Bibi. The defendant number 1, Abdul Saddar, is the son of Muslimuddin through his wife Adjan Bibi. Adjan Bibi died when defendant number 1 was only 7 months old. Plaintiffs are the sons and daughters of late Muslimuddin through his second wife, Mirjan Bibi. 25, 6, 7, 8 are daughters of late Muslimuddin, were given marriages at the time of marriage. Properties were given to them. As such, they are not entitled to get their share of the suit property. Late Muslimuddin had 75 bighas of cultivated land along with other properties which were distributed among the sons after his death. During his lifetime, Muslimuddin had made oral gift in respect of land measuring 6 bighas in favor of defendant number 1. Accordingly, by dint of said oral gift, the defendant number 1 used to live separately from his family members and enjoyed his land donated by his father. Accordingly, the defendant number 1 acquired right, title, interest, possession over 6 bighas of land of the suit partner. Therefore, it is submitted that he has every right to sell these 6 bighas of land. In the year 2000, the defendant number 1 sold land 4 bighas out of 6 bighas of land in favor of defendant number 2. And accordingly, the defendant number 2 had been possessing the said 4 bighas of land by constructing his dwelling house thereon. Again, defendant number 1 sold measuring 2 bighas on 24/6/13 out of said 6 bighas of land, which he had obtained by oral gift from his father in favor of him. And accordingly, the defendant number 1 executed a registered agreement in favor of defendant number 3 for selling land measuring 2 bighas at a consideration of rupees 2,40,000, out of which 1,40,000 was paid to him.
These are all agreement to sale.
Agree. And accordingly, on the strength of said registered agreement, the defendant number 3 had been possessing the land by constructing dwelling house and residing there along with his family members. In view of the
These are sometime in 2000, 2013.
My lord,
No,
My lord,
two dates, right? 2000 and 2013.
okay, my lord.
Yes.
And since then, we are in possession. My lord, the issues are first, whether Schedule A land of the plaintiff was amicably partitioned among the plaintiff and defendant number 1 being legal heirs of Muslimuddin. Whether Schedule C land of plaintiff fallen on the shared land of the plaintiff on the amicable partition with the defendant number 1. As such, they have exclusive right, title, and interest thereon. Whether defendant number 2 and 3 forcibly disposes the plaintiff from scheduled land of the plaintiff. Whether defendant number 1 has legal right to make any agreement for sale of scheduled land in favor of defendant number 2 and 3. But others are not required that much. So, my lord, I will go to issue number, next page, issue number 1 and 2. Issue number 1 and 2, my lord, A scheduled land, whether it was amicably settled. As both the issues are more vital, therefore taken together for discussion first. According to the plaintiff, after the death of their father Muslimuddin, an amicable partition of land measuring 14 bighas of suit, dark number such and such, between plaintiff and defendant number 1. And accordingly, plaintiff got scheduled land, and while land measuring 1 bigha being share of defendant number 1, falls in B scheduled land of the plaintiff. PW1, plaintiff witness Abdul Haya, plaintiff number 2, deposed that after the death of their father in the year 1997, land measuring 14 bighas of suit number such and such were amicably partitioned between themselves and defendant number 1. As per the said amicable partition, they got C scheduled land of the plant, while B scheduled land measuring such and such in the share of defendant number, which is described as B schedule B of the plant. It is pertinent to mention here, as per order dated 5/8/15, cross-examination of PW1 and 2 were forfeited. So we have been not allowed to cross-examine them. Huh? Because PW1 and 2 were not cross-examined. We are not allowed to cross-examine.
You're not allowed to cross-examine.
Because it is pertinent to mention, as per order dated, cross-examination of PW1 and 2 were forfeited.
Why?
Because, my lord, adjournment petition was sought for, that was written in there.
That was rejected.
That was rejected.
On what ground?
My lord, that is what is there in that. It was my lord, at page 13. My lord, not page 13. It is. That is in the. It has been discussed in the appellate that because I sought adjournment, it was rejected.
Okay, anyway, we'll go to that appellate court later. Yes, then
PW2 Abdul Qasim, who is an independent witness, has also corroborated the evidence of PW1. The defendant side had not adduced any evidence to rebut the said evidence of PW1 and 2. If you are not allowed to cross-examine, how could you rebut? Therefore, the oral evidence of PW1 and 2 proves that A scheduled land was amicable partition between plaintiff and defendant number 1 after the death of Father Muslimuddin, and they got C scheduled land, while B scheduled land fell in the share of defendant number 1. There is no dispute between the parties that plaintiff number 1 to 8 and defendant number 1 are the sons and daughters of late Muslimuddin, who was the owner of A scheduled land of the plaintiff. Therefore, after his death, the plaintiff
So only PW only 1 and 2, both the petitioners,
my lord.
both the plaintiffs, no? Both are brothers.
Brothers of the second wife.
No,
And
what PW2 is an independent witness.
PW2, who is an independent witness, and
Who is he?
PW1 plaintiff number.
Who is PW2?
PW2 is Abdul Qasim.
But who is he?
My lord. That issue is not there. Only that who has corroborated the evidence of PW1.
Correct, but who is he?
Nothing has been stated in there.
The records are there, you find out.
There's a brother.
Huh?
He is an independent witness.
But it says Abdul Qasim, who is an independent
Independent
witness. What is independent witness if he's a brother?
Record have.
No, Abdul Qasim, yes, he's not brother. So
Correct.
I thought Abdul Haimara.
So, but you check, records are there.
Well,
Find out what does he say? How has he corroborated? Because he's an independent witness.
well,
Has he, did he witness the settlement?
or without that.
Correct, because we don't know, it only says corroborated the evidence of PW1.
And my lord, both were not.
Rupak, records to Telecom, did you? You ask your junior, Mr. Roy Chaudhary,
No,
to.
Yeah, yes.
Did you comment? Let us see if their evidence, what they are saying.
I continue reading that.
Yes, yes.
In note Kh on the reverse page of Exhibit 3, the Jamabandi copy of the suit land reveals that as per order dated 8/8/11 passed by learned Revenue Circle officer, the name of the plaintiff and defendant number 1 was mutated for land measuring 14 bighas on the strength of inheritance from predecessor late Muslimuddin. Thus, it appears there is no perfect partition of the suit land. However, it is not necessary that imperfect partition, manual partition by meets and bounds cannot be effected without perfect partition. The defendant number 2 and 3 pleaded that defendant number 1 got land measuring 6 bighas as oral gift from his father Muslimuddin in the year 1990. But Exhibit 1 makes it crystal clear the name of defendant number 1 and plaintiff are duly mutated in the respect of the entire land measuring 14 bighas out of the suit dag number such and such on the strength of inheritance from their father, late Muslimuddin. DW2, Abdul Hasim, who is defendant number 2, in his cross-examination has admitted he did not purchase 4 bighas of land from Abdul Sattar by registered sale. He also admitted that Muslimuddin did not execute any deed of transfer for land measuring 6 bighas in favor of Abdul Sattar. Similarly, DW3, Joinak Khan, who is defendant number 3 of this suit, in his cross-examination deposed that he was not present when Muslimuddin had donated 6 bighas of land from the suit patta to Abdul Sattar. There is absolutely no legal reliable evidence to substantiate the plea of defendant that Muslimuddin made oral gift measuring 6 bighas of suit dag in favor of defendant number Abdul Sattar. It appears that plaintiff number 1, 2, 3, 4 and defendant number 1 are the sons and plaintiff number 5, 6,
But
7.
at this stage, the Jamabandi indicates the names of the plaintiff
And
as
defendant.
record and the defendant number 1 as recorded rights
Of the whole
holder of
of-
the 14 bighas,
14.
out of which you claim some.
They claim 12 bighas and I was given
No,
1.
whatever. You meaning, I mean to say your defendant number 2 and 3. They have bought about
By agreement to sell from the 6 bighas of sale.
from the 6 bighas. But you see now the rights of the plaintiff
No.
on the strength of the Jamabandi entry recorded on strength of the inheritance appears in the record of rights.
Record.
In contrast, your right is from an agreement to sale.
Mal. From an agreement to sell. But
This is the
if I take it,
factual,
factual.
isn't it? Admitted fact.
but
There
if
is
I
no
take it
dispute.
that way also, if it is 14 bigas, my lord, one and the plaintiff gets from 14,
Whatever.
7 bigas,
you
7
see,
bigas.
we don't know about that.
But-
We don't know about all that.
Mal.
Right now, those facts are not before this.
So amicable settlement, my submission, my lord.
Now,
amicable
now
settlement
you see, defendant number, the amicable settlement,
was not proved by the plaintiff,
it has been proved.
my lord.
It has been proved
Why, my lord?
because defendant number one chose not to rebut. Because defendant number one, after receiving notice,
my lord.
he did not choose to file his WS.
And then
It was for him.
my lord,
It was for him,
my lord,
not for you.
my lord,
Correct?
my lord.
You cannot know what transpired between one and him. What kind of an amicable settlement had entered between them. You are not in the best position. You could have only brought him as an evidence to show. But he had got an opportunity. Court had given him notice.
I brought him
Now, if he does not deny those averments
my lord,
in the plaint,
my lord.
consequence will be what? That those facts
My lord, I
will
brought
be
him
stand proved.
my lord, I brought him
We will come to that later.
I-
We
only
will
submission, my
come
lord.
to that, Mr. Roy Chaudhary. But I am asking you a very specific question right
my lord,
now.
written statement was not there, so there is no denial.
There is no denial.
My lord, what I want to
So,
place,
so you see the amicable settlement. If one by one, I am only
Lord,
don't get
queries.
intimidated.
No,
I have not decided
I'm also
anything.
trying to learn, my lord.
I have not decided anything.
No, man.
But I am only trying to
My lord, place the
appreciate
questions.
correct, appreciate the facts and apply my mind. Now it appears, therefore, it therefore appears that you cannot really say that the amicable settlement is not proved because non-filing of the WS itself proves there is no denial. CPC will come, non-denial of the
Order 8.
order 8. So I mean, one can go in that way, right? Anyway, let's not get into all that right
Well,
now.
can
Let's
I make one
complete this.
submission here?
Yes.
I brought defendant number 1 as DW4.
That order I need to see. Why was he not allowed?
No, my lord, his evidence was discussed. In this issue number 1,
You brought whom?
defendant number 1 as DW4.
Correct. He was not allowed.
No, my lord, he was not allowed to
Give evidence.
Evidence.
Because he did not file his WS.
WS.
That appears to be a bit erroneous to me. Why was he not allowed? He could have always stood as a witness for you. There is
By
no
saying
bar.
that at least his name is there in the Jamabandi as the legal heir of Muslimuddin. He has some right over the land.
That you have a point. You see, because he was the best person.
Best person to give the real facts.
But since he was an arrayed party, he chose not to file a WS and participate. In that situation, is there any bar for him to be brought as a witness?
No, well, I don't think.
Because you see, in the witness box now, he can improve the case.
Well,
He can say that there is no amicable settlement. But
he cannot file evidence on his behalf as a defendant number 1.
No, that I understood. No. But as your witness, he can say that there is no amicable settlement.
So that aspect of the matter, why not court will allow me to have the discussion on that? And it was an expert, virtually and one-sided discussion. No,
that because he did not come. Now I'm only asking you, Mr. Roy Chaudhary, is there any bar then? Because he's an arrayed defendant. He received his notice. No. He entered appearance. He sought time for filing WS. He chose not to participate thereafter. All the pleadings against him.
Then he filed affidavit.
Then he filed affidavit of evidence.
Which was rejected. Then he brought as a DW4 by the defendant number 2 and 3, which was not allowed.
So that appears. I'm not sure whether you will need to enlighten me on
this
that
aspect
part
of the
of the,
matter, this ap-
because otherwise you're right. On the face of it, I'm with you
my lord.
on that.
But I have to substantiate my submission with some legal.
Correct. Because otherwise, yes, you are right. You know, if you wanted to produce someone as your witness, and he definitely has a vital say, how can he not be allowed?
Probably he was brought as witness, my lord.
No, he was brought in a witness, but
DW4.
as DW4. But the trial court said, ki, no, we will not allow you because you did not file your WS. But he has been brought as a defense witness.
Yes, defense.
Defense witness don't have to file WS. So that part has, you see, that opportunity was not given. Despite had he have been brought, maybe he could have brought something.
But if my lord, your lordship may turn to page 17, where it has said in the issue number 3,
Yes,
paragraph number 3,
DW4.
who is the defendant number 1 has proved that he executed exhibit A agreement for sale. That if he is exhibited, then he was allowed, and this submission was not there in issue number 1 and 2. Where is the submission of in different issue number 1 and 2? If he was allowed to prove the exhibit agreement to sell, then why his submissions were not there in deciding issue number 1 and 2?
Something doesn't look correct here. Have you seen the record?
My friend is going through it.
Why don't you go to the records? We can have this matter on another day.
Let it remain part. It will be because let it remain part, and your lordship will fix the date.
I have no issue.
No, but this needs to be clarified because you see, Mr. Roy Chaudhary is correct. At page 17, again, it has shown DW4. Is this defendant number 1 has proved that he executed exhibit A. How did he prove?
Because probably in the exhibit A, probably his signature is there.
No, but how did he prove?
Because that document is probably
How he proved? He did not file a WS?
No.
Then how did he prove? He was not allowed. He was not allowed to be cross-examined. At page 33, on the above issues, plaintiff side has adduced evidence of 3 witnesses and exhibited certain documents. Evidence of plaintiff side remained without cross-examination as right of cross-examination was forfeited. I want to know this, why it was forfeited. This is one query I've been having. Due to rejection of petition for adjournments. I want to see those orders. Why were adjournments rejected? Defendant number 2 and 3 has also adduced evidence of 3 witnesses and exhibited some documents. They were duly cross-examined by other side. However, affidavit of defendant number 1 as DW1 was rejected as he did not file any WS. Subsequently, the defendant number 2 and 3 examined the defendant number 1 as their witness. I think this was allowed. I think maybe Mr. Roy Chaudhary, DW4 evidence is there.
My lord, if it is allowed, there is no discussion even deciding issue number 1 and 2.
No, then you have to show me what is there in the evidence.
That is what, my lord.
What is there in the evidence? If suppose he has not said anything about the amicable settlement, then where is the need of discussion?
Discussion, my lord.
Exhibit, my lord. It's not clear.
Clear, my lord.
It's not clear.
We'll go through the documents.
You go through the documents.
I mean,
Heard Mr. P.K. Roy Chaudhary, learned counsel appearing for the appellant. Also heard Mr. A. Chaudhary. A.U. no? Same. A.U. Chaudhary. No, you write A.U. or A?
Actually, A Chaudhary.
A. Chaudhary. Because here it is mentioned. That's why I got confused. A. Chaudhary, learned counsel for the respondent. Upon hearing the matter briefly, it appears that though the learned counsel for the appellant contends that the defendant number 1, though was produced as DW4 before the trial court, however, he was not allowed to be examined is not clear as per the reading of paragraph 11 of the appellate court judgment. That apart, it is not clear as why the evidence of plaintiff's side was not allowed to be cross-examined by the defendant number 2 and 3 stroke appellant during the trial court. Mr. Roy Chaudhary seeks a short accommodation to go through the records of the trial court to bring to look into the aforesaid to assist in this regard. I think those two. Anything else you need to check up from the records?
My lord, we'll go through all the evidences.
And you go through the evidence.
And I will try to collect the certified copy of this one.
Just let us be more clear.
My lord.
Of course, this court is exercising a second appellate court
Ma-
jurisdiction. This court is not going to appreciate and reappreciate the evidence.
Yes.
But at the same time, this court needs to know whether there is any evidence or no evidence.
No evidence. Or there is a perversity.
Correct. That definitely falls within the power. To that extent, this court will have to see,
Shall
because it seems there is some. It is not absolutely clear. The judge, as regards this aspect, some doubt is coming. Only to that extent. I'm making myself clear.
Well, but definitely. At least I have the opportunity to place again the before your lordship.
So when do you want it?
My lord, some time to get the certified copies, my lord.
No, we will not give you a lot of time. Otherwise, it's difficult to keep matters part-heard. So next week, choose a date.
After 10 days, my lord, can I make a small prayer? If my lord, if lordship gives the permission that we may obtain in the order, judicial order, that we may be allowed to get the certificate copies of.
No, that you apply, you will get it. You don't need a judicial order for all this. Repost on such and such date for further hearing. Next
After
week, Thursday,
10
did you? Thursday, Mr. Roy Chaudhary, you get it. You have enough time. Otherwise, I'll forget.
Well, definitely. Next week.
Otherwise, no point of
Let it
keeping
give
the
a part
matter.
of, madam. Let it give
I have said further hearing.
go further.
Otherwise, it makes no point of
My lord,
keeping it as a part-heard. The entire idea of keeping it part-heard is to ensure that by the next date,
It
this
is over.
court
It is
can
correct, madam.
bring the matter to its logical end. Right?
Highly obliged.
This is the first appeal.
How, lordship? First appeal against the order.
First appeal against order, FAO. Yes. What was Mr. Roy saying? Foul. I was wondering, I was trying to understand. Now I got it. Yes.
May I please? My lord, here the appellant as a plaintiff is the owner of a plot of land measuring 2 kathas 1.5. And the respondent lordship is the builder, which is a respondent number 1, DS Realtor is a partnership firm. So
Yes. Yes.
So the respondent approached the appellant plaintiff lordship requesting that the plaintiff should give the land for the development and a development agreement should be executed and the plaintiff should give executed irrevocable general power attorney. Then the appellant plaintiff had agreed to the proposal given by the builder. Then a development agreement was executed between the party and the plaintiff, that is the landowner lordship, also given an irrevocable general power attorney in favor of the defendant builder lord. In the agreement lordship, there are specific clauses that the building will be constructed within a period of 36 months plus 6 months grace.
A building will be completed within
within a period of 36 months, Lordship.
36 months.
Your Lordship,
You are the owner.
I am the owner.
You are the owner. You are Mr. Rahul, na?
Builder.
You are the builder. Who is the builder?
DS Realtors.
Okay.
It is a partnership firm.
Yes, the 36 months. Okay.
That agreement I have annexed, Your Lordship. Your Lordship, may please to come to page.
We will come to the pages
Ah,
just in nutshell.
Yes. So accordingly, in the similar manner, Lordship, along with 28 other landowners, this builder, Your Lordship, enter into various agreements in respect of more than 10 bighas of land, Lordship, in 2014 and 15. In the present case, Your Lordship, the development agreement was executed and registered on 19/2/2015. So 3 years period, Lordship, expired in 2018. But till date, the building has not been completed, Lordship, and in respect of the other 27 numbers of landowner, also the building has not been constructed, Lordship. And interesting thing is this, Lordship, the firm, that is the builder, Lordship, has not registered itself till date under the RERA, Act of RERA 2016.
That became mandatory from when?
Mandatory.
From when?
From when, Lordship, in Assam, this Act is of 2016, but in Assam it come into force with effect from 9/5/17.
9/5/17.
17.
Mandatory from science of
Yeah,
17.
and here, Your Lordship, the RERA Act provide that even if a development agreement was executed earlier into coming into force of the RERA Act, but the building is not constructed, or possession certificate has not been obtained from the local authority, or completion certificate has not been obtained, then the provisions of the RERA Act will apply.
In that situation, an appeal should have been filed before the tribunal.
My lord, it was
Well,
actually what has happened, my
I
lord.
am submitting.
My lord, the RERA authorities, they did some adjudication and they directed some penalties against the
20
builder.
lakhs, plenty
And
was
the
imposed.
builder went on before the appellate authority. The appeal was lost, and now they are before the High Court, my lord.
This is that appeal.
No, that is
That's
RERA
different.
appeal. That is RERA appeal.
So there is a separate proceeding.
Separate proceeding. No, my lord, High Court has admitted the appeal. My lord,
But no
request
stay has been
called
granted.
for, my lord. And because of.
So you've been already penalized.
Yes, 20 lakhs.
But we have not.
Understood.
Portion has been deposited.
Understood, but you have been already, a
Order
penalty
has
has
been passed.
So
Order has been
you
passed.
so the tribunal have already recorded you as a defaulter. That
Not registered.
For having not registered.
Acha for that.
But we took a plea, my lord, that the entire project went into dark, my lord.
Anyway, that
That's
is
a separate
different.
issue.
But here the issue, I think they are seeking compensation because
Not exactly, my lord.
then
Now
for
this-
specific performance.
No,
No, Lord.
suit is-
My suit is for declaration of right title interest, cancellation of the development agreement, and recovery of possession.
So basically, yeah, cancellation of that irrevocable power of attorney, right? Because I think
A development agreement and power.
and that irrevocable power, that is your
Yes.
the suit was for that.
Yes.
And that suit was ultimately you failed in the suit.
No, suit
Not
is
decreed.
pending.
These
Suit pending.
proceedings before your lordship are
So-
only
so this
regarding
one-
the injunction part. my
So this is now this you are aggrieved by which order, Mr. Roy?
I am
Mr.
agreed by
Chaudhary?
the impugned order.
Sorry, Mr. Roy.
Along with the plaintiff, your lordship, I have filed an application under order 39.
Let us see that. Let us see that order.
Order
Page
71,
page 71. 71. This is the impugned order.
Very cryptic order without discussing the three golden principles of the injunction jurisprudence. My injunction petition was rejected. May I read?
Yes, please.
No. By this order, I am proceeding to dispose of the instant misjudged case number on petition number so-and-so filed by the plaintiff petitioner under order 39 rules 1 and 2 with the section 115 for restraining the defendant theremin agent so-and-so from undertaking any construction over the suit land, from changing the nature and character of the suit land, and from encumbering the suit land in any manner. By the petition it is submitted inter alia, the petitioner being the owner and possession of the suit land, executed a registered deed of agreement dated 19/2/15 and 19/2/15 in favor of the partnership firm of the OPs for the development of the suit land and constructed a multi-storage building. On 19/2/15, the petitioner husband offer vacant position of the suit land to the OPs. As per the agreement, the OPs were obligated to obtain building permission within 9 months from the date of execution of the agreement and to complete construction of the building within 36 months from the date of obtaining permission from the concerned authority. As per the agreement, the petitioner also executed an irrevocable general power of attorney in favor of the OP, being deed number so and so dated 19/2/15. The petitioner grievance is that in spite of the taking possession of the suit land, the OP remained dormant and did nothing to construct the building. The petitioner was taken by surprise when the OP shown him photocopy of the building permission dated 22/9/17. The petitioner, unable to agree with the assurance of the OPs, demanded cancellation of the agreement as well as the power of attorney. It is also submitted the OP has mutated their names in respect of DAG number 357 for measuring 19.5 lesser of Patan number 892. On these facts, the petitioner has submitted that the OPs are intending to grab the land of the petitioner, hence the petition. The OP have filed the written objection inter alia that the petitioner handed over possession of the suit land formally to the OP only on 2/2/17 by swearing an affidavit. It is further contended that the OP applied for building permission on 10/8/17 after entering into agreement with one of the pattadars of the project on 15/6/27. That the OPs have invested a huge amount of money for the development of the suit land since the agreement, and that the petitioner has filed the present suit only to harass the OP. It is also pleaded that if injunction is granted by the court, then the OP will suffer irreparable loss and injury, and the other 27 landholders of the project will also bear the brunt. I have heard learned counsel appearing for both the sides and peruse the materials on record. The respective cases of the parties have been narrated above. As it is borne out from the materials on record, the plaintiff executed a development agreement dated 19/2/15 with the defendant's court. Development of the suit land within a specified period of time, as mentioned in the agreement. However, admittedly, the defendants have not completed the construction within the established time period. As such, I find that the plaintiff has been able to show that he has a prima facie case in his favor. The suit land was handed over to the defendant for the purpose of construction of the flats. From the photographs annexed by the defendants, it is evident that already the defendants have invested a huge amount of resources for the development of the suit land. Learned counsel for the defendants submitted that many intending buyers have entered into the agreement with the defendant for the purchase of the residential flat. That being the situation, I am of the opinion that no fruitful purpose is likely to be served by restraining the defendants from proceeding with the construction at this stage of the suit, as that would not only cause loss and injury, inconvenience to the defendant, but also to the intending buyer, whose investments are at stake in the project. Delaying the execution of the construction project as planned by the defendant will certainly defeat public interest, which is a relevant consideration for the purpose of the deciding the injunction petition. In the aforesaid factual circumstances, the plaintiff has a prima facie case in his favor. In other two principles of grant of temporary injunction are not operating in his favor. So my petition was rejected. Absolutely perverse finding and contrary to the provisions of the RERA Act.
What is perverse?
Because Lordship, as per section 3 of the RERA Act, a builder, your Lordship, until and unless is registered under with the RERA authority, cannot advertise for sale, cannot enter into development agreement.
But this is, you see, your suit has not been finally disposed, right? You have asked for injunction. Your case before the trial court in the injunction case was that you have now come to know that they have already obtained permission. Now, according to you, they could not have obtained the permission behind your back.
They obtained the permission in planning permission in 2017.
In
Lordship,
2017.
it was to be as per the agreement, it was to be obtained within 9 months.
But they did it after delay. After delay.
After delay.
And then they have not completed the construction with a stipulated period of time, which is an admitted fact. Admittedly, they have not been able. Then therefore you wanted that they should be stopped. They should not be allowed to do the development. There be an injunction stopping them from carrying on the development. Correct? This was your case.
My submission is this, Lordship, the learned trial court, while rejecting my petition, has held that it will cause irreparable loss
That's
and injury.
because the balance of convenience has to be also weighed. It has
Balance
come
of
to
convenience has to be weighed, Lordship, between the parties. Because, Lordship, if your Lordship is pleased to take up the RERA Act.
Yes, give me.
The builder cannot do anything, your Lordship. For there is a criminal punishment provision in the RERA Act. And then when
Where is that application
for what?
for injunction?
I'm coming to that.
No, let us see that first.
Okay.
Let us see what are the grounds you have taken.
Grounds taken in the present
Yes,
memo
yes.
appeal.
No.
Injunction.
Yes.
46.
Page
46.
46.
46.
Yes. Para 8, you have talked about that that permission you have to take taken within 9 months. Paragraph 9, you talk about the completion, clause 5.1. Then para 10, you talk about the irrevocable general power of attorney. Para 11, yes, you may read from para 11.
Para 11, that it may be mentioned herein that the opposite party defendants, after taking the possession of the land, remained dormant and had done nothing to construct the building and obtain building permission from the authority for almost 30, it is typography, almost 30 years.
But
It will be 3 years, Your Lordship. Typography. Other places it is 3 years. The petitioner plaintiff repeatedly requested the opposite party to construct the building, but the opposite party defendants did not give any heed to the request of the petitioner. The opposite party defendants got the agreement executed, thereby occupied the land of the plaintiff by giving false promises. The petitioner, para 12, that the petitioner plaintiff on several occasions visited the office of the opposite party defendant number 1 and requested the opposite party defendant to start the construction of the building, as because the land which was given to the opposite party defendant is the only land of the petitioner plaintiff, and the petitioner plaintiff requires his share of the property at the earliest and within a stipulated time. So the petitioner plaintiff can enjoy and reside in the flat. The opposite party defendant all the time assured the petitioner plaintiff that they are going to start the construction of the building within a month or two. But till date, the opposite party defendants have not constructed the building and falsely assuring the petitioner plaintiff about the start of the construction of the building. The action of the opposite party's defendant is nothing but a deception and the fraudulent, and also land grabbing by virtue of the deed of agreement dated 19/2/2015. Para 30, that it may mention herein that the petitioner plaintiff went to the office of the defendant in the first week of October 17 and asked the opposite party's defendant to cancel the agreement and revoke the power of attorney because the opposite party defendants are not complied with the terms and conditions of the development agreement dated 19/2/50 and breached the agreement. The opposite party defendant to utter surprise of the petitioner plaintiff had given a photocopy of the building permission dated 22/9/17 to the petitioner plaintiff, and they said they are going to start the construction of the building shortly. The petitioner plaintiff did not agree with the assurances of the opposite party defendants and demanded the cancellation of the agreement as well as the power of attorney dated so and so. But the opposite party defendant refused to do so, so rather badly behaved with the petitioner plaintiff and virtually thrown out from his office. Para 40, that it may mention herein that the perusal of the building permission dated 22/9/17, it is transpared that the opposite party defendants had applied for the building permission only on 10/8/17, whereas your lordship agreement is of 15. Whereas as per the agreement dated 19/2/15, the opposite party defendant is required to apply for the building permission within 9 months from the date of execution of the agreement dated 19/2/15. So the conduct of the opposite party's defendant is clear.
Mr. Roy, you may continue reading it, but I have finished reading it and I do not find any ground of the Real Estate Regulation and Development Act
That is a
being
matter
taken.
of law,
No,
lordship.
I was just trying to see whether any foundation, any ground
No,
has
no,
been taken.
regarding RERA.
That you have not taken.
No, RERA, that because it is a pure question
So,
of
and
law.
it is also,
In the-
Mr. Roy, I am only asking you a fact.
No,
I am
that is-
asking you a fact.
No, your
Don't
lordship
become
is correct.
don't become so defensive.
No, no.
This court knows what is to be allowed
No,
and
no,
what is
regarding,
not to be allowed.
regarding.
So it is a fact that you have not taken this particular plea that which you are now taking before this court during the injunction application, and it was also not argued because I don't find anything reflected. It was argued,
No, it was argued, but not discussed.
not discussed,
A
because
very-
I don't see it was recorded.
No, lordship, not recorded, the lordship. The recording is absolutely
Okay.
perverse, lordship.
All right.
Because
Now let us see what is this ground you want to take.
when I
from
filed
the
this
re-
appeal, lordship, this honorable court granted injunction in our favor, which is still in.
Not granted injunction, stayed.
In the interim
This
order,
court stayed, right? Give you an interim protection.
interim protection. Now, your lordship, may please to peruse section 3 of the Red Act.
Yes. Yes. Prior registration. Prior registration.
Section 3. Section 3 heading is lordship, prior registration of real estate project with real estate electricity authority. No promoter shall advertise, market, book sell or offer for sale or invite persons to purchase in any manner any plot, apartment, building, as the case may be in any real estate project or part of it, in any planning or building planning area without registering the real estate project with the real estate regulatory authority established under the Act, provided that the projects that are ongoing on the date of commencement of this Act and for which the completion certificate has not been issued, the promoter shall make an application to the authority for registration of the said project within a period of 3 months from the date of commencement of this Act. So, your lordship, then provided further that if the authority thinks necessary in the interest of the allottees for projects which are developed beyond the planning area but with the requisite permission of the local authority, it may order direct the promoter of such project to register with the authority, and the provisions of this Act or the rules and the regulation made thereunder shall apply to such project from that stage of registration. Anything contained in subsection 1, no registration of the real estate project shall be required where the area of the land proposed to be. Don't think this, if the area is less than the
Not required.
10 flats, then registration.
Understood. So
Here-
here they have violated rule section 3 of the Act
Yes.
because they went ahead advertising and getting the bookings done and all before getting the registration.
Before getting the.
Understood. And accordingly, you have also filed
Complaint before
a
the.
complaint before the tribunal, and the tribunal has already given penalty to them. They can
Lordship, the tribunal appointed GMD and GMC lordship, constituted a inspection committee.
So that inspection report was in your favor.
Submitted the report.
Understood it, because ultimately the tribunal gave a finding in favor of you.
Yes.
Which is why now they are before the appellate court. Correct?
Yeah.
Understood.
Apart from that, lordship, the funniest thing is this: there are serious allegations of fraud.
But
Committed.
this court cannot go into all that right now about all those allegations.
No.
Now tell me one thing. It appears that this court, the injunction court, has given a prima facie finding in your favor.
Yes.
I remember you had read it out, right? It says prima facie you have a case. Now, after recording that prima facie finding in your favor, what are those law on injunction?
The competing balance
So,
of
so you
opinion.
show me
irrevocal
those.
laws and
What are the law which is in your favor? Show it to me, because it appears that the trial court have recorded one finding, which I think is in your favor. Yes.
regarding prima facie.
Yes, the petitioner's grievance is that in spite of taking yes. As such, I find that the plaintiff has been able to show that he has a prima facie case in his favor. This is the recording. So prima facie case, according to the trial court, you have made out. However, the trial court did not give you the injunction that you had asked. So show me the law.
Yes.
Show me.
Now, first of all,
Let us stay focused on that issue now.
Yes,
Because this is the order which you are challenging. Prima facie satisfaction of the court is already in your favor. So let us see the law on injunction.
Yes, law of injunction, lordship. First of all, I like to place before your lordship the fraud committed by the defendant.
Let us not
No,
go
that
into
is-
the
that-
fraud.
that-
Mr.
that is-
Roy, if you want an order from this court, please show me the injunctions cases. I'm sure you have brought those cases today, because that is.
Cases I have, because those are well settled law
No,
and your lordship.
Mr. Rahul, where are those cases on injunction? I'll take it up too if you don't have it now. I'm disposing of this case today. Where are those cases? The law on injunction.
law of
Golden
injunction.
principles, 3 golden principles.
Where is it?
All has to be available for the.
Give me the
Yes,
decision.
ma'am.
You have come to the court on a hearing matter,
Okay,
and none of you are armed with the authorities. Where are those days gone when the councils used to carry 2-3 books of bags full of books, and the juniors used to get tired carrying them from the parking to the corridors, through the corridors to the court? Those days have gone away, or what? Then now too, you also have the advantage of your mobile phones. It's just a click. You don't even have to take all this trouble carrying bags full of books. Very, very strange matters are for hearing, and councils are not even having the decisions.
No, I'll place it, madam. Okay.
Yes, you want to say something more?
Prepare a fraudulent sale deed by scanning. By that sale deed, Lordship, the appellant plaintiff has purchased the suit land from one Harendra Kumar. What the defendant did, Your Honor, because a photocopy of the my sale deed was available with the defendant respondent, Lordship. So he scanned it, and whereas in the original sale deed, I am the purchaser, Lordship. By scanning, he showed that the defendant 2 and 3 are the owners of the land, Lordship. And they got mutation from the office of the circle officer, and their names were shown.
Where are these facts in your injunction application?
Yes, these facts are.
Where are these facts in your injunction application before the trial court?
No, my lord, I have filed the additional affidavit in the.
That is that we are not on. Where are the in your injunction application against which this impugned order was passed? Where are all these facts?
Lordship, I had pleaded in my memo appeal, Lordship. And
The memo of appeal has not been, it was not before the, these are factual aspect, Mr. Roy. Mr. Roy, these are factual aspect.
Lordship, when.
Anyway, I have taken note of the fraud that you have argued. Anything else?
Lordship,
Any more other points?
No, Honorable Chief,
adjournment. Any other points?
No, Lordship, the Honorable Chief Justice directed the police commissioner to investigate the case of the fraudulent sale deed. And matter
Of which? Of your case? Of
yes,
this case?
yes.
Mr. Rahul, is there any order?
And charge sheet has been submitted against the. I have annexed Lordship.
But I am not aware of.
Lordship, I have annexed.
Where? Which page?
Yes.
Page.
Yes.
It's a matter of trial.
Page.
No. First of all, your Lordship will be pleased to come to page 111.
Page?
111.
This is a sale deed. Where is the order of the court?
Yes.
Where is the order
Page
of the Chief
158.
Justice?
Page
Page
158.
158.
58.
158.
It starts from 159.
Who is Debashish Ghosh Sanjeev?
Partner of the builder, defendant number 2 and 3. Devashish Ghosh and other is Sanjeev Bhatta.
A criminal case is pending against these two persons.
And the Honorable Chief Justice directed the police commissioner to investigate regarding the fraudulent sale deed for sale deed. Accordingly, a report was submitted that your Lordship will find.
You mean this court? Because it is this is a judicial order.
Yes,
I thought there is an order in the administrative side because you're
No, no.
referring to the.
on the administrative side also report is there.
No, it's all right. It's a judicial order passed by this court.
Yes. All these documents were filed before the learned trial court lordship before injunction hearing. But nothing is mentioned in the impugnator. Silent. And page 162 is the report.
What is this fraud that you are highlighting?
Lordship, I have purchased a plot of land measuring 2 kathas, 1.5 lachas in the year, your Lordship, 1984 from one Harendranath Kumar, and which land was given for development to the present defendant respondent Lordship. What the defendants 2 and 3 did, Lordship, they were already in the custody of my Xerox copy, Lordship. So they scanned it. And in play, though I was the purchaser in the original sale deed, the defendants showed their name as the purchasers. And they applied before the GMDA Lordship for obtaining a building permission along with my balance land, your Lordship. And the GMD granted the permission, Lordship. And mutation, defendants succeeded in getting the mutation in their name. When I lodged complaint with the circle officer cancelled the mutation of the defendant number 2 and 3. I also lodged complaint before the GMD for the cancellation of the building permission because for this 19 lachas of land, the builders have shown themselves to be the owner. To be the owner, Lordship. Your Lordship, when in the development agreement, Lordship, my land is mentioned, Lordship, how they will become the owner, developer, Lordship. So Lordship will see the report. Findings, it starts from page 162. Finding, Lordship will find at page. Page, Lordship, 165, para 1 to 3. Lordship got it? Page 165, para 3. It
One
starts-
second.
It also works like
Page.
165.
Yes.
160, third para.
What is this
This
document?
is the report of the Deputy Police Commissioner.
Pursuant to the order of this court.
Yes.
Page 165, yes?
165, third para.
Yes.
It is also worthwhile to note that the accused persons never and ever disclose that they have a plot of land measuring 1 katha in the same dak and patra during the relevant period of time. Therefore, it is established that the accused persons have manufactured the deed of sale in favor of them therein purchased from Sri Harendranath Kumar. The same fact is very much evident from the statement of the original Patadar Sri Harendranath Kumar, that the vendor, he had neither executed any sale deed with both Devashish Ghosh and Sanjeev Bhatta. It is stated that correspondence have been made with Circle Officer Gauhati, Revenue Circle, and could learn as follows. The accused of Panbajar PS case number has submitted an application form for mutation case number so and so and tag number so and so, pata number so and so of village Gotanagar, Moja, Dhalagwari, Moja, and a copy of the letter issued by the Circle Officer is enclosed annexure 2. Accordingly, the accused got mutation. Mutation is case number so and so, 1617 so and so, so and so, and subsequent entered their name in the Jamabandi. A copy of the letter is annexure number 3. It appears from the review order that the mutation of the name of the accused persons in mutation case number so and so was cancelled, and order for correction of the land record and reinserted the name of the original Pattada, that is the present appellant. I have believed that the Original Patadar Harendranath Kumar clearly stated that he had not executed any sale deed with Devashish Ghosh and Sanjeev Bhatta and failed to recognize them. The accused persons have taken possession of the land under the deed of agreement being number so and so dated 19/2/15 and irrevocable general power attorney dated this and that for construction of a three super deluxe flats. However, the terms and conditions as laid down has already been expired, but the accused are taking plea of the deeds kept in the land in their position till date. After completion of the investigation, the case was returned to see a charge sheet under charge sheet number so and so, so and so. And charge sheet also, I have an actual law. So there is a serious allegation of fraud as ordered by the Honorable Chief Justice. The investigation was done. The investigation report was submitted. The accused person, that is the present respondent number 23, has been charge sheeted. Trial is going on. Apart from now, not only that, Lord, I had lodged a complaint against the forgery, Lordship, in the Panbajar PS case number that respondent 2 and 3 has prepared a manufactured sale deed, Lordship. Then in that case, the present respondent number 2 and 3 preferred a anticipatory bail application. In that anticipatory application, the respondent number 2 clearly stated that they are the owner of the land and not the present appellant, Lordship. That application also I have found. That your Lordship will find at page.
Yes, I've seen that. That is referred in the order of this court, whereby the deputy commissioner was directed to file an inquiry report. I've seen all that.
Inquiry, but in the anticipatory bail petition.
Got it.
When the name of the respondent number 2, 3 were cancelled by the circle officer on my complaint, Lordship,
They have said that
filed,
it is there.
and the FIR was lodged. They, in the anticipatory bail application, in para 12, has stated that they are the owner. The respondent number 2 and 3, they are the owners of the land measuring 1 kata.
Okay, noted. Anything else?
There are many things, Lordship.
No, you can't go on with many things. This is a case of injunction now. Anything related to the
I'm submitting
injunction?
on injunction, my lord.
Yes,
When
yes.
there is a fraud, Lordship,
I have taken note
Lordship,
on that.
Lordship,
Anything beyond
it is
that?
settled law.
Mr. Roy, I have taken note of your submissions on fraud. Anything beside that is there?
No, Lordship, I am submitting on the injunction matter also, Lordship. In case of a fraud,
I've understood.
leaves
I've understood
everything
that.
behind. Fraud leaves everything.
I've understood that and I've noted. Anything besides that I'm asking.
So, before passing the order, Lordship, there is actually, your Lordship is well versed that there are 3 golden principles of the injunction jurisprudence.
Where is that decision?
That is the balance of prima facie case, balance of conviction.
Where is that case?
Cases, Lordship, there are many cases.
Where is it?
Akmal Ali versus State of
I
Assam.
don't know. You want a case? Why
I am having in my.
why are you all not carrying the
No,
case
no,
laws?
I have
Give
to
me
take.
one.
I
Give the citation.
will submit it.
Give it.
I have to take print from my.
No, you give me the citation,
Oh.
Mr. Roy.
Give that. 1969, 1969 में क्या है ना, division. Citations are, Lordship. 1984, AIR Gauhati 86.
Give me one. Don't give me.
This is the full bench decision.
Just give me one. Whichever one you want to rely, give me one of the golden principles.
Golden principle, that is
Just give me one decision.
1984, AIR Gauhati 86. This is a full bench.
Lekhila? 19.
Then other.
All right. Let us hear Mr. Rahul now.
No, I have not completed.
You have not completed. Yes.
Please allow, Lord.
Yes. I'll allow you till till the break.
Yes.
Not beyond that. At 2 o'clock, I will hear Mr. Rahul.
Now your lordship may please to High Court order concern. Peruse the order by moving the this file lordship. The stay has been
All
granted.
right, I have taken note that you have a stay, that is only a temporary measure. Finally hearing I am doing it now. I'm not bound by any orders passed earlier in the proceeding.
कहाँ और नहीं फाइल में नहीं कहाँ नहीं? This is the order lordship in the IA.
Yes,
IA number 21.
I don't have the IA before me right now. Hey, to the IA to the. इधर आ सकते हैं।
IA कौन था?
ये IA to the order, stay order to लिया गया ना? Stay
IA number lordship
order.
2372 of 23.
2372.
Which I have annexed also.
The
In
order to
IA. Sorry. No. There is a contempt petition in which I have annexed that order.
No, what is the order date?
Order date is lordship. Twenty-nine.
Pardon?
Order date is 29/9/23.
That is the IA file. The IA file is bigger than the main file.
This contempt.
Lordship, that is annexure number.
So that was next person again. It will have a second.
I always take to the file.
Yes, till the next returnable date, the respondent opposite parties are restrained from carrying out any further construction over the suitlet or changing the nature and character of the suitlet, and from encumbering the suitlet so as to create any third-party rights till the next date of listing. This interim injunction is being granted on the submission made by the learned counsel for the applicant that the project of the respondents opposite parties is not registered under the so-and-so act. Therefore, it is made clear that if the project of the respondent is registered under the RERA Act, this order of injunction shall not be given effect of. Now, this was not followed. That is why you filed a contempt. Why did you file a contempt, Mr. Roy?
Contempt were filed when this restraining order was passed. The builder is proceeding with the construction day and night law.
So then what happened in the contempt? It's still
Contempt
pending.
is fixed today for hearing.
It's still pending.
Today it is fixed for. So my submission, your lordship, will be pleased to consider. Why
Yes.
this honorable
I
court-
think in sum and substance, your submissions are like this. Correct me if I'm wrong. Number one, that the provisions of RERA has been violated because they went ahead without registration. This is your first submission. Second submission is that they have also
Committed fraud.
taken recourse to fraud, which has already been taken note by this court in another proceeding, and in pursuant to the direction given by this court to the deputy commissioner, a report has also been submitted, wherein it has come out that the partners of this particular firm has committed fraud.
Yes.
Right?
And charge sheet has been.
And charge sheet, and that mutation is also on a complaint given by you. The mutation has been cancelled.
Cancelled.
These are your submissions.
Yes, and on that for fraudulent mutation lordship, the respondent, that is defendant, obtained building planning permit from the GMC and the working permit from the GMC lordship.
But Mr. Roy just
these are
pleaded, I understood, Mr. Roy. But what I'm thinking is, because suppose can we do it like this? It appears that before the injunction court, these things were not mentioned in that injunction application. Now you have brought out all this, which shows that yes, you have a point. So can it not be remanded back to the injunction court to take to hear it back? Until then, I will allow continuation of the interim order which has already been passed here till final disposal. That can be also done.
Yes.
Why should this court
Because
get into?
lordship-
Because today already you are protected by an interim order.
Yes.
Correct. You are already protected, and it appears on the face of on a prima facie, it looks that these fraud, everything, you may have brought it before the trial court by some affidavit, but in that injunction application, they were not there. And also in that order, which is under challenge, these things are not recorded.
Not recorded.
However, you have submitted that you have argued.
Correct.
Correct. No, I have said no, Mr. Roy. Why are you not hearing me? I have said that it is filed by additional affidavit. So since these were already part of the pleadings, and that since you and after hearing, it appears that perhaps these things should have been also taken note of by the injunction court while deciding the injunction, specifically because the injunction court prima facie found you have a case. So in that view, I'll remand it back. Mr. Rahul.
Only one, my lord.
Only-
Indulgence,
let
I will
let
like
me
to
submit
seek,
one.
my lord.
One second, Mr. Roy, you have submitted enough.
No,
Now
only
this
one
court
thing.
is also with you. Give an opportunity to Mr. Rahul now. Yes.
Well, only one indulgence I would like to seek, my lord. If they seek to amend the injunction petition,
No, it's not about amendment of injunction petition. They may file additional affidavit if they wish.
against that additional or whatever pleading they bring on record,
You will get an opportunity.
I reserve
Of course,
my right
of
to
course.
file a written objection.
Of course, you'll get a
Only
right.
that much.
I will clarify it that
Because
the
I have-
injunction court,
Yes, my lord.
the injunction court will give a due hearing to both parties,
Both
and
are-
after hearing both parties, will decide if afresh.
Lordship,
Until the decision of the injunction court, the stay order will operate.
lordship.
And I will ensure, and I will put another paragraph there that if there is any violation of the stay order, serious consequences will
Yes,
follow.
True, my lord.
You tell your client.
Definitely, my lord.
He cannot go on merrily violating the orders of this court.
My lord, what has happened, my lord? All these fraud allegations, I have taken instructions from my client. Those things have been already settled.
No, we don't know about all
Yes,
this,
Lordship,
but you see,
everything
it appears on record. A lot of allegations have come.
If they
In
bring
fact,
this-
it appears from the report of the deputy commissioner itself that the mutation was cancelled on a complaint given by the petitioner, plaintiff, sorry.
all these LDs have been, my lord, surrendered, nothing has been. claimed
Whatever,
back.
you
If
all take it up before the
Exactly.
injunction court now.
If they bring these points through a written, my lord.
You file an
application,
reply.
We can file our objection and we can also.
All
place
right,
our-
I can clarify. Mr. Roy, I may also, he's also right, since he also needs a opportunity to rebut all
course,
this.
Lordship,
So
I have-
you can, I will give you the liberty to file an additional affidavit bringing out all these points, despite the fact that you have already submitted that they are already there in some pleadings. Be that as it may, for the purpose of the injunction, whatever you want to say, I'm giving you the liberty. He will get a chance to file his rebuttal, and thereafter the injunction court will give a fresh hearing.
Injunction order passed by this honorable court earlier will continue.
Not injunction,
disposal.
interim order.
That-
The interim order that is already continuing will continue till final disposal of the
Unlike-
injunction. Okay, I think that should take me. At 2, I'll give the order because it's already, if I start now, I don't think I can finish the order. I think 2 o'clock would be appropriate.
Okay.
Otherwise, it's very difficult if there is a break in the flow. Mr. Rahul, just.
There are many other fraudulent act of the respondents.
All right. Since you said there are many, if you keep starting, maybe then you will not get a disposal today. Do you want a disposal or you don't want a disposal?
Of course, Lord. I also want disposal.
It will at least get some. It will that.
Only one line, Lordship. Why this honorable court passed interim order in my favor? Only on the ground that they are not registered under RERA.
No, I've seen. You
So
see,
you-
you
until
Mr.
they are
Roy,
not registered.
Mr. Roy, after seeing that only I'm with you.
Oblige.
I have seen that.
Oblige.
Lordship was indicating something finally. Something was coming from our lordship, my lord.
I forgot.
Again.
No, Mr. Rahul, get me one of the decision on that injunction power.
Yes, lordship.
If you-
Justice,
if you-
Justice Jain Sharma's judgment is there. where-
Just one.
60%.
If you get it, you give it to him.
Yes, lordship. 95.
Right now only.
Lordship.
I will also submit one.
No, no, don't submit more, just one. I am dictating at 2 o'clock. I'm not hearing it anymore.
High Court Division Bench.
Just one I wanted to
Okay.
have.
This case has a checkered history, my lord. It is a third round of litigation before this honorable court. Lord,
What is this case? This is item
19.
19, enhancement of maintenance.
Yes, against this.
You are the wife
Yes,
and you are the husband.
yes.
What is the maintenance?
10,000 interim maintenance was granted by the my lord. Against that order, I assailed that order by filing the criminal revision petition. That was dismissed on the ground of maintainability, my lordship. Doctrine of binding precedent, this honorable court said. Against that order, I went to this honorable Supreme Court. Supreme Court has, my lordship, dismissed the SLP, but liberty was granted. You file under Article 227.
So you have
As a-
come by way of 227 now.
But unfortunately, my lordship, the case was filed under Article 226. Then division bench has passed, given liberty to file. You withdraw this petition and file this.
So finally, the 227 has come.
Yes, my lord.
And what does the husband do?
As of now.
Huh?
Builder, my lordship.
Builder.
Yes, my lord.
He cannot pay 10,000. Oh no, no. He is paying enhancement.
Enhancement, my lordship. And other.
And what does the wife do?
Nothing, my lordship. The case was transferred.
Any children?
No, my lord. This is his second wife, my lordship. From first wife, he has a adult son, my lordship. And from second, nothing.
So
He said, my lordship.
right now, the second wife is before this court.
Yes, my lordship.
This is the second marriage.
Second marriage of the husband, my lord.
First marriage also was divorced. And now you are against the interim maintenance. 10,000. Any
As of now, we-
one second. Why are you interfering? 10,000. 10,000 on what basis was 10,000 fixed?
My lordship, there is the family court has not given reason, my
Let
lordship.
us see that order.
Yes, my lordship. Kindly see page 22, my lord. Running page 22. 22, just the court has narrated the my lordship, and 23, my lordship. Hence, the meantime, having regard to the aforesaid admitted facts and taking other relevant factors into consideration in the light of the relevant provisions of under which the instant petition is filed, I have the opinion that the opposite party is directed to pay rupees 10,000, which is, in my opinion, is just and reasonable. And if lordship can see the affidavit filed by the husband, my lordship.
Where is that?
My lordship, page 100.
One second. Can you read the first part of the order? Page 22.
Yes, my lord.
The petitioner stated.
Stated
Read
that the
from the-
opposite party inflicted continuous mental and physical torture on her, for which she is compelled to live separately from the opposite party. It is stated that she does not have sufficient income, and as the opposite party has failed to give any maintenance allowance to her till date, she is facing great financial hardship to maintain herself. It is further stated that the opposite party is having real estate, money lending, construction business, and has several property in and around Coimbatore and Bangalore with worth of about rupees 5 crore, and from all sources he earns more than 3 lakhs per month, my lordship. The opposite party has not disputed his marriage with the petitioner. The opposite party denied having monthly income as alleged by the petitioner, and also denied of being a real estate business or money lending, earning more than 3 lakhs per month.
The petitioner is also earning about 25,000 per month.
My lordship, when she was in Coimbatore, my lordship, she was in hospital, my lordship. She was getting 20,000.
She was working as what?
My lordship, she was working as a attendant, my lord.
So why is she not working now?
She's not getting her job. She is now 50, my lord. She's 50 years old.
Means why don't you increase 10,000 to by another 5,000,
No, she-
15,000?
That is my humble.
This is interim.
Already my allied senior is getting 20,000. 10,000 from this order, lordship, And another 10,000 as a house order, lordship. that is in
Residential
the-
accommodation,
Lordship
my
may
lordship.
kindly see.
I filed the petition before the in a DB, my lordship. And where I got this order 10,000,
10,000.
Or-
He is getting 20,000
Me-
as of now, lordship.
let me complete.
No,
Against the 10,000, my lordship,
So, so right now you are getting how much from the husband?
20,000.
Total 20,000. Out of which 10 is your interim and 10 is towards house.
Yes, sir.
House allowance.
Of, rent of the accommodation, my lordship. Though I have
So
all-
how much do you want now?
my claim, I have paid, kindly see, pay, para 36 of the petition, my lordship.
Yes.
It's page 14. Everything, my lordship, I am seeking a very basic
How much?
thing.
How much you are seeking? Let's see.
50,000, my lordship.
No, no.
The income, my lordship, the man is maintaining, my
Where
lordship,
have
BMW.
what documents are there to show what is the income of the petitioner? Sorry, the husband.
Will kindly see, my lordship.
But
He
this is-
himself has said, my
No,
lordship,
no. This is only your statement. Where has he said?
financial affidavit, kindly see.
Where?
Page 100.
Page 100.
My lordship, page 100.
Where? Let us see how much is his monthly income he's showing.
Showing monthly income is 50,000, my lordship.
Page 100.
100 is the financial affidavit starts.
Relevant.
103, my lordship. Monthly income, he has retained 50,000.
And you want 50. You want the entire monthly income. You don't want him to survive. No, we are not getting into all so much. Mr. Counsel, please confine yourself to the query posed by the court. Please show me where is the monthly income, which page and what paragraph?
103.
103.
Running page. F, details of income of the
50,000.
50,000.
Okay.
Now come to lordship page, this page 100.
Yes.
The column, my lordship, general monthly expenses of the applicant, 20,000.
Yes. Yes.
Now kindly see, my lord, page 101.
Yes.
Details of dependent family members.
Yes.
What he has written, my lordship, age and sex, 84 years mother and 29 years son, who is a chartered accountant earning in lakh salary. And he has shown 29 major son as a dependent.
Okay, next.
Next, my lordship. The approximate expenses incurred on account of 30,000, my lordship. Now kindly see, my lordship.
Yes.
This next page, assets, movable and immovable property, page 104.
Yes.
Dwelling house, vacant plots.
Yes.
The kind of house, my lordship, kindly see, it's just like a
All right,
palace, my lordship.
next.
Now kindly see, my lordship, 105.
Yes.
Details of loan taken or given by the loans taken, Ravi 10 lakhs, Alex 18 lakhs. Now kindly H, details of liabilities. Personal loan 28 lakhs, car loan 10.3
All right,
lakhs.
Mr. Counsel, we will not examine that in
No,
detail.
what
You
I'm
see,
saying-
Mr. Counsel, you are on an interim maintenance.
Yes.
I was trying to figure out what
Yes.
the monthly
Yes.
income, because we are not adjudicating on the main case right now.
Correct.
Correct? So let us not unnecessarily go into.
No, I am not going. I am.
I have understood what you are
Yes.
trying to project. So beyond this, anything else? Because
My submission, my lordship, he has.
according to
if
you,
he-
he has the capabilities of giving you more than 10,000 as a interior maintenance, and that 10,000 is what you are getting is not sufficient for you to live a decent life right now. Correct? This is what your submission is.
106, can you see
Yes.
what he is doing? Builder consultant. I am not going on this trading, my lordship,
What
shares.
kind of a builder he is?
Project. He has a
Partnership
project,
firm.
and he has a project in Andhra Pradesh.
Aurelia Real Estates and Builders.
Yes, my lordship.
Yes, have you filed your income tax returns? What is your income tax return shown?
At present 50,000. I was doing service in a company lawsuit. And I have retired from that company. Now I am aged out 66, 67 years old lawsuit. And my 86-year-old mother is dependent.
Are
on
you
me.
a builder or not right now?
Yes, lordship.
You are a builder? Are you, you are
I was
still a
builder.
partner in Aurelia Real Estates and Builders?
No, not at present. Earlier, I was a builder and I was a partnership in that company. Presently, because of this, I am not in.
Where is your latest income tax
Lordship,
returns?
that is here. I have got it.
You have not
Lordship.
filed it.
That is not on record, lordship.
What is the income shown from there?
50,000 lordship. 45,000. And
Give a copy to the other side. I'll take it up at 2 o'clock.
And who cost me lordship 50,000?
2 o'clock.
Yes, lordship.
It will.
your lordship.
One second. Miss Counsel, where is Mr. Roy? He'll come, no? All right, because I have changed my mind in that matter. So I will need him. Huh? Anyway,
My lord, I was directed to submit the IT return. Yes. Should I submitted the.
Before I conclude, your lordship,
20.
me to say something, my lordship. Income tax on the basis of personal, he is just given me the copy, my lordship. Regarding my lordship, he is trading from the account of mother, my lordship.
all right,
And
Mr.
two-
Counsel, I'm not going into
And-
all these things right now. You
the-
see, this is a case of interim maintenance.
Interim maintenance, my lordship.
Now, I will not unnecessarily venture into some investigation as regards the income source. We will not take that. This court shall not undertake that exercise at this moment.
The basic.
Because
need-
the case is of interim maintenance, this is a revision petition under 227. I cannot sit and appeal against the decision that has been already taken. This court will only interfere if there is something perverse.
Yes, my
Right?
lordship.
Now,
Yes,
now you see there is already an affidavit of income already has been filed before the trial court, before the family court, which indicates 50,000 as monthly income.
But there is a contradiction, my lordship. The
Whatever,
EMI, my lordship.
that you keep arguing in the main case. The case
What
has
I am
not been.
submitting, my lordship,
Mr. Counsel, I'm sorry, but
am
I'm
saying, my
rejecting
lordship,
this.
I will leave it to my lordship.
Because it's
but
a
I am just
discretion. It is
submitting,
only
my
an
lordship.
interim maintenance. It's not
If-
final maintenance.
Correct, my lord, correct.
Now, it appears from this affidavit that his monthly income is 50,000. You are already getting 20,000. Now, if I have to increase this, what will be left with him?
My lord,
So
kindly
it is not looking
see. The
reasonable to me
standard
now.
type, my lordship.
I'm sorry,
What
Mr.
he
Counsel,
was
it is not
giving, my
reasonable
lordship,
right
kindly
now.
see, my lordship. I
Yes.
am only making my submission.
Yes.
And I leave it to me.
Yes, yes,
And lordship may pass the order, my lord.
yes.
My lordship, kindly see the page 13, what I have stated before the family court, my lordship.
Yes, please say it.
Yes, my lordship, this chart I have given, rental income 14,000, my lordship.
Hmm.
This medical, my lordship, she is suffering, my lordship. This 10,000, my lordship. And then housekeeping 2,500.
Hmm.
This electricity 1,500, my lord.
All right.
Personal expenses. So these are the basic
Okay, I've
needs, my lordship.
understood. Understood. Yes, your name?
Lal, my lordship.
Elal.
Yes.
Sorry, Mr. Elal. Heard Mr. Elal, learned counsel appearing for the petitioner. Also heard Mr.
And to,
Your name?
M.I. Hussain.
M.I.
one thing
M.I.
I would
Hussain.
like to
respondent.
add, my lordship.
Yes.
My enhancement petition appeal is pending before the session court, my lordship. Where enhancement of the residential accommodation which has been
All
done.
right, fine.
So that will not affect.
Mr.
my-
Counsel, take your seat now.
Yes.
The present petition under Article 227 of the Constitution of India has been filed seeking enhancement of the interior maintenance rupees 10,000 granted by the learned Family Court 2, Kamrup M. Gauhati, hereinafter referred to as the Family Court, by order dated 28/2/2023, whereby now in FC criminal case number 162 of 2023, whereby the respondent husband has been directed to pay a sum of rupees 10,000 per month to the petitioner wife. Counsels, please take your seat. Next para. The con
28/7 loss.
huh?
28/7 order is 28/7.
ठीक बोलो. 28/7. 2023. The contention of the petitioner is that the respondent is a builder and developer and is financially well placed, whereas the petitioner is not employed and has no independent source of income. On the aforesaid premise, enhancement of interior maintenance of rupees 50,000 per month has been sought. Per contra, learned counsel for the respondent submits that the learned family court has passed a well-reasoned interim order after considering the affidavit of assets after considering the affidavit of income stroke assets stroke liabilities filed by the parties. Both parties are filed by the parties, full stop. It is contended that the respondent's disclosed monthly income is rupees 50,000, and apart from paying interior maintenance of rupees 10,000 per month, the respondent is also bearing an additional amount of rupees 10,000 per month towards the accommodation expenses.
Yes, Mr. Under DB Act.
Towards the accommodation expenses of the petitioner under the
Order passed by
under the
Domestic.
one second. In
Protection
terms
of women
one
under-
second, in terms of the order dated
order dated 26/6/2025.
26/6/2025
2025.
in
DB case number 88 of 2024.
okay
Pending before the JMC 1.
ending before the JMFC 1.
1. Kamrup Metro.
This is under what section of the DB Act?
First 12, section 12 under the complaint, my lordship, the interim relief 23.
No. I am asking about the DB Act.
Section 12.
Section under section 12 will log ID, under section 12 of the so and so Act.
This interim,
Section 23. Appeal has to file under section 12.
No, that pending proceeding in the DB Act is under what section?
Order is passed under section 23.
2023.
residential accommodation deal section 20.
Residential accommodation expenses, huh?
D.
Can you just ask your junior to give these details?
Yes,
Just give the detail of the order, the number of the case and
Yes,
the
my lordship.
section.
He will give.
Just give it in a piece of paper, please. It is therefore urged that the claim for enhancement is wholly disproportionate and beyond the respondent's financial capacity.
This order
Thi-
has been
thi-
challenged
thi-
by
this,
the
this
respondent.
court has considered the rival submissions and passed the material placed on record. At the outset, it is to be noted that the jurisdiction under Article 227 of the Constitution of India is supervisory in nature and does not permit this court to act as a court of appeal or to reappreciate facts unless the order challenges unless the order under challenge suffers from patent illegality, perversity, or jurisdictional error. The Learned Family Court has taken into consideration the affidavits of assets and liabilities filed by the parties. Hey, by income, assets, liability, as mandated by law. The affidavit of the respondent husband reflects a monthly income of rupees 50,000. There is no material placed before this court to prima facie demonstrate suppression of income or that the respondent is earning substantially more than what is disclosed. Next paragraph. It is also not in dispute that apart from interior maintenance of rupees 10,000 per month, the respondent is already paying an additional sum of rupees 10,000 per month towards the residential accommodation expenses of the petitioner.
Which is under challenged by
Thus-
the respondent.
Thus, the total monthly financial outgo of the respondent towards the petitioner as of date is 20,000.
May I say? my lordship?
As of date is,
They have-
that is not required.
For this.
It's all
order,
right.
my
That is not before this court.
Yes.
The prayer for enhancement of interior maintenance to rupees 50,000 per month in the facts of the present case would virtually amount to directing the respondent to part with his entire disclosed monthly income, which is neither reasonable nor sustainable at the interim stage. Interior maintenance is intended to provide immediate succor and prevent destitution pending adjudication of the main proceedings. It is not meant to determine the final rights of the parties, which shall be decided on the basis of evidence led before the learned family court. This court finds that the learned family court has exercised its discretion judiciously and within the settled parameters governing grant of interior maintenance. No perversity, illegality, or jurisdictional error is made out, warranting interference of this court under Article 227 of the Constitution of India. Accordingly, the petition is devoid of merit and stands dismissed. It is clarified that the observations made herein are confined to the adjudication of the present case and shall not prejudice the rights and contention of the parties in the pending proceedings before the learned family court or domestic violence is before which court?
Before JFMC.
Or before any other court.
Lord, one thing here. This petition is pending since 2023. The trial court may be directed to dispose of
Next.
time bond, my lord. Time bond at least. my
Next.
lordship.
At Koediba, it is needless to be clarified that the family court shall expeditiously decide the matter. To edit Koediba.
Obliged, my lord.
Yes. Yes, where's Mr. Roy?
Much of the matter is still going on in the district judge's court. I haven't.
Ma'am. It will last. You see, Miss Counsel, after going in, during research on thinking the matter, ultimately, I'm exercising the powers of First Appellate Court, right? Now, unless I find that the order of the trial court is arbitrary, capricious, or perverse, I cannot interfere. Right? Now, you may be right in saying all this about the RERA violation, about the frauds, about the mutation cancel, but these were never there in your application. They were not there. Of course, RERA violation is perverse. That is only a submission, law submission. But where is the factual finding? That
But in a similar matter.
those similar matters were not before the injunction court. You have not said all that in your injunction application. You were privy to all these informations. They are not subsequent events. You know it.
There were subsequent events.
No, that order came when at the during the while I'm sorry, that injunction that was refused is of 2023. That affidavit of deputy commissioner is something in 20, isn't it? So these were privy to you. You may have kept it in some application, some affidavit, but that specific application which was pressed is your injunction application. In that injunction application, nothing mentioned.
A suit amendment application is pending. We have introduced all these facts.
No, but they are not before this court. Right now, I'm adjudicating the correctness of the rejection of the injunction. And that under the, in terms of my powers under order 43. I cannot travel beyond it. I'm not exercising a 226 or a 227 jurisdiction right now, isn't it? Mr. Raw has come. Mr. Roy, you see, over a cup of coffee, I was recapitulating all the fine arguments that you made, which to an extent before going for the break, I was almost convinced. In fact, you are right. All these frauds appears to have come. But the problem is, I am exercising powers under Order 43, FAO. You're apparently, on the face of it, your injunction application does not talk about the RERA violation or the frauds or these mutations being cancelled, nothing. Whatever you have stated in the injunction application have been taken note of by the injunction court and found that yes, you have a prima facie case. Despite that, after weighing the scales, the court found that no, at this point, it shall not be in the interest of justice to stop the developer and refuse the interim injunction. This is the discretion which the injunction court exercised. Now, for this court, while exercising jurisdiction under the first appellate court, unless this court finds that that discretion is wholly arbitrary, capricious, or perverse, this court cannot interfere with it. How so, even if this court feels that no, perhaps it would have been better if these points are taken to the injunction court, if the question of fraud, the violation of RERA, these are brought in. That is the problem.
Lordship, my reply is this. Your Lordship, please to consider that in the pleading there should be only factual position, Lordship.
I will take note of it.
The learned trial court, while rejecting my injunction, have found that if the injunction is granted, it is the intended purchasers who will suffer. But Lordship, learned trial court failed to consider the basic fundamental thing that if there is no RERA registration, Lordship, under section 3, he cannot advertise, he cannot sell, he cannot enter into a development agreement. That is the vital question.
Understood.
And that document was filed before the learned trial court, Lordship.
Understood.
In that event, Lordship, it will be, I think, proper to call for the LCR. Everything I have filed, Lordship. But the learned court did not care.
Which is the provision of the RERA which defines the powers of the tribunal?
Lordship. Ample power is given.
No, why these matters have not been taken there? If there has been a violation of the RERA, all these issues could have been taken up.
May I just apprise your Lordship?
Huh?
May I just apprise your Lordship? In fact, the RERA issue has been taken according to the RERA Act, my lord. According to the RERA Act,
No, what I just wanted to know for my academic understanding, what are the scope, what kind of matters are taken before the RERA, whether these issues can be a subject matter under the RERA?
Registration, my lord, insofar as registration is concerned, registration is a matter for the licensing authority, the original jurisdiction, whoever exercises the RERA authority,
Okay,
real estate authority.
okay.
Now, my lord, they can also entertain complaints from the, my lord, those prospective purchasers who have entered into agreement and whose cases have been defeated. That's a different subject matter which
Okay, but what about a developer? What about the owner of the land? If suppose a developer has taken his land
Lordship.
and without getting registration, he started developing. Will
Lordship.
he also have a can he also approach the tribunal?
My lord, insofar as non-registration is concerned, my lord,
That I understood.
to that extent, there has been some.
Where do I get it? Which is the provision here?
My lord,
I just wanted to see.
to that extent, they have filed a complaint.
Mr. Counsel, which section defines?
Section 3.
Come to the provisions. Before that, may I just indicate to your lordship?
Yes.
This will be relevant, may be relevant, my lord. They filed a complaint. The assessing authority found that yes, the registration was not done and the project has commenced. So they imposed a penalty and directed for registration. Against that particular order, appeal was filed before the
By you?
Yes, lordship.
By you?
Lordship. Before the appellate authority. The appeal was dismissed. Now, as per the RERA Act, there is a provision for filing second appeal before our Honorable High Court. That has been done. The appeal has been admitted.
Do you have the order of the tribunal?
Tribunal's order?
Against which you have filed an appeal?
Lordship, I think they have annexed it.
Mr. Roy, is that order enclosed? Yes, page. What is your name, ma'am?
B. Rai.
Right.
She is my grand.
Miss Rai, page
167.
Not
67.
167.
She is my granddaughter.
This is the order of the RERA.
Yes. Very detailed order has been given. This order was passed after constitution of a joint committee of the GMD and GMC. And apart from that, Lordship may be pleased to consider this permit which was obtained by the builder, Lordship, expired in 2019. Thereafter, the construction permit has not been renewed. But they are doing constructions, Lordship. Without building permission, construction cannot go.
My lord, I have taken instructions from my client, my lord, in so far as the registration part is concerned, my lord.
Yes.
They are processing the registration and it will be soon be registered.
Okay, Mr. Rahul, anything more you want to say?
Insofar as the main appeal is concerned.
Yes.
My lord, it has already fallen from your lordship right now that as per order 43, my lord, the contours of the appellate court are marked by many judicial pronouncements, my lord. Lordship gave me an occasion to go through some of the judgments. I just placed two judgments, my lord. One is on the very principle of, my lord, granting injunction. Because that principle also supports me, because that judgment of the Honorable Apex Court lays down the criteria that whose burden is it? Whose burden is it to satisfy the court that it's a case for injunction, my lord? If this is the lordship might have been already aware, Dolpot, I am taking Dolpot Kumar.
Yes, give the citation for the benefit of the other side.
Yes, lordship is 1992 1 SCC, page 719. I think my learned senior already knows that Dolpot Kumar versus Prahlad Singh.
They are very famous.
It's a very famous judgment. Well, may I
I'm
just-
sure Mr. Roy must be also relying on this in many cases.
No,
I have given to attendance.
No, that I know, but Dalpat also you must be relying in
I-
some other cases.
Many cases.
why not? It has always been a
Yes,
learning experience watching Mr. Roy.
Yes, yes.
Well,
He
from
is a
paragraph
jurisprudence in civil law.
No, sir.
Yes.
Paragraph 4, my lord. Order 39, Rule 1C provides that temporary injunction may be granted where in any suit it is proved by the affidavit or otherwise that the defendant threatens to dispossess the plaintiff or otherwise cause injury to the plaintiff in relation to any property in dispute in the suit. The court may by order grant a temporary injunction to restrain such act or make such other order for purpose of staying or preventing or disposition of the plaintiff or otherwise causing injury to the plaintiff in relation to any property in dispute in the suit as the court thinks fit until the disposal of the suit or until further orders. Pursuant to recommendations of the Law Commission, Clause C was brought on statute by Section 86(1)(b) of the Amending Act 104 of 1976 with effect from February 1, 1977. Earlier thereto, there was no express power except the inherent power under Section 151 to grant ad interim injunction against disposition. Rule 1 primarily concerned with the preservation of the property in dispute till legal rights are adjudicated. Injunction is a judicial process by which a party is required to refrain from doing any particular act. It is in the nature of preventive relief to a litigant to prevent future possible injury. In other words, the court on exercise of power granting ad interim injunction is to preserve the subject matter of the suit in status quo for the time being. It is settled law that granting injunction is a discretionary relief. Lordship has already indicated. The exercise thereof is subject to court satisfying that there is a serious disputed question to be tried in the suit and that an act on the facts before the court, there is a probability of his being entitled to relief asked for by the plaintiff public defendant. 2, the court's interference is necessary to protect the party from the species of injury. In other words, the irreparable injury or damage would ensure before the legal right would be established at trial. And the comparative hardship or mischief or inconvenience which is likely to occur from withholding injunction will be greater than that would be likely to arise from granting it. Now, my lord, paragraph 5. Therefore, the burden is on the plaintiff by evidence illued by affidavit or otherwise that there is a prima facie case. Prima facie case, Lordship has already taken note of. The learned trial court has held that there is a prima facie case. But insofar as the other ingredients are concerned, my lord, regarding balance of convenience and irreparable loss, the plaintiff failed to satisfy the court. Because, my lord, in my limited understanding, the bundle of facts is always derived from the pleadings in the plain. The appellant side has just now submitted that the RERA aspect, being a legal aspect, there need not be any pleadings to that effect. But if we again go through that injunction application, my lord, we at least whisper on some fact that RERA registration has not been done. Leave it about the legal side.
Followed.
But there is not a single whisper about the RERA registration having been done or not done.
They have been repeatedly saying that somewhere it has been mentioned. Where, in which pleading is it mentioned?
Nowhere it has been mentioned. That is why I went through the entire memo of appeal which they have.
No, not the memo of appeal. Before the trial.
Exactly, my lord. Whatever they had, whatever pleadings were exchanged between the parties before the trial court at the relevant point of time,
There nothing.
they have tried to bring it on record by through their memo of appeal.
There nothing.
There is nothing, my lord. They are saying that there was an affidavit, but I could not also locate that affidavit.
Okay.
So that being the situation, my lord.
Okay.
Now that subjective satisfaction which was derived by the learned trial court while refusing to grant injunction, my lord, that cannot be substituted by the appellate
Correct. You're right, Mr. Rahul.
Lordship.
That you're right. The powers of the first appellate court, I don't think Mr. Roy is going to also have any quarrel.
Okay.
He will try to bring home the point that in the context of the present case, the order of the injunction court is perverse. But he shall not otherwise upset the settled position as regards the first appellate court powers.
Lordship.
I am sure of
Lordship.
that.
In that aspect, only I just want to rely upon that Antox judgment. Lordship.
Antox, yes, I have
Lordship
it.
said.
1990 supplementary SSC 727.
Lordship.
Yes, I have it.
Antox.
I have it. I have a copy. I have my own copy.
Then, my lord.
I think you'll rely on para 9 probably.
Lordship.
9 and 14. Which one you are talking about? Wonder Limited versus Antox?
Yes, Lordship. Yes.
Huh? or some other case.
Yes, that 1991.
Correct.
Yes, Lordship. That was specifically.
Just give me your paragraphs you want to rely, because I
No, no,
thought I thought
basically
9,
the-
14 and 16 would be relevant.
Radhabari judgment, my lord, actually.
Okay, give me.
The Radhabari judgment, okay.
Yeah.
The book has been given, my lord.
Oh, this one. Yes, yes. Yes, I have it. Yes.
Lordship will come to
This
paragraph
is
41, my lord.
one of my neighbors. Yes.
MK Bhattacharya.
Yes. Very sad demise.
Happens to be my relative also. My lord.
Yes. I'm sure Mr. Roy also knows that incident at Rani, and then in Tinsukia. No, ultimately it happened in Tinsukia. Very sad. Burnt alive. Yes.
His wife was my aunt.
Oh, okay. Yes.
My lord, paragraph 41 from paragraph 41, Lordship. If your Lordship takes note of the heading of paragraph 41.
But Mr. Rahul, now you're going to delay the disposal. I'm telling you, don't burden me with more decisions.
Your Lordship, with the entire reading of the paragraph. I'll just, Lordship, it has already fallen from your Lordship. I'm just placing my judgment.
Yes.
My lord, it says, what is the appellate court's power and role in dealing with an order of injunction passed by a trial?
Yes, please read.
My lord, answers are in paragraph 41, 42 and 45.
Yes, please read.
Paragraph 41. While considering the scope of an appellate court's power to interfere with exercise of discretionary jurisdiction of a trial court in matters of injunction, it needs to be borne in mind that an appeal against exercise of jurisdiction is really an appeal in principle. The appellate court will therefore not reassess the materials and seek to reach a conclusion different from the one which has been reached by the trial court if the conclusion which the trial court had reached was a reasonably possible conclusion on the materials on record. Least exercise of discretion is interlocutory applications such as injunction becomes wild, unwieldy, unpredictable or arbitrary, and the courts have evolved certain principles which govern certain exercise of such discretionary powers. The principle that in order to obtain an interlocutory order of injunction, a party must satisfy the court that there is a prima facie case to go for trial, the balance of convenience is in favor of the granting injunction, and there would be irreparable loss if injunction is not granted, are principles which have been consistently followed by courts so that some judicially determinable parameters remain available for the purpose of deciding of discretionary powers, exercise power of granting injunction has or has not been justifiably granted. Three golden principles which govern the grant of injunction are nothing but conditions which are required to be satisfied by a party in order to enable to obtain an interlocutory order of injunction. My lord, thereafter, court goes to discuss the Antox judgment, my lord, and the relevant paragraph is quoted now in paragraph 42. I'm not bothering your lordship by reading the entire thing. And finally, in paragraph 45, paragraph 45, the summation is, does an appeal against exercise of discretionary jurisdiction is really an appeal in principle, and that is why, unlike a regular appeal in the ordinary sense, where whole evidence on record is examined anew by the appellate court, what is really examined in an appeal against exercise of discretionary jurisdiction is the legality and validity of the order, and it can be set aside and should be set aside only when there is patent error on the face of the record or order is against the established or settled principles of law. If two views are possible and a other view, however appealing, would not be allowed if the substitute in place of the trial court's view, which are otherwise reasonable and logical. Same thing here, my lord.
Okay.
Two views have become possible.
Yes.
And my lord, this prima facie satisfaction may be different for different.
Okay, I've understood.
This is my submission, my lord.
Yes, Mr. Roy.
Lordship.
Yes, Miss Rai. Page.
Lordship may be pleased to come to the
Plaint.
plaint, Lordship.
Page.
Second portion is at what, 41?
No, page, give me the
Page
page.
lordship, 41.
141,
No, only 40.
41.
41 of the how, no? How, yes, how.
Yes. Yes. Which paragraph?
Yes, para lordship.
You get a fraud, individual record, use of time.
Yeah, you have mentioned about the deputy commissioner
Yes, yes.
and all this, the forged documents.
Forged document, all things mentioned.
This
lordship,
is,
nothing no, whisper in the.
this is part of what?
Well, plain.
Plaint, amended plaint.
Yes,
When did you amend this plaint?
this amendment plaint is dated lordship.
Twenty.
25/9/21, page 36.
25/8/21.
Yes, 21 lordship. And all fraudulent actions have been narrated in the plaint lordship, and in the injunction petition it is clearly mentioned that the averments made in the plaint and the document filed in the plaint will be treated as a part of the injunction application lordship. But the learned trial court passed the impugnment in such a whimsical manner lordship. Nothing has been considered. Lordship, fraud leaves everything behind. If there is a fraud, lordship. And already the charge sheet has been submitted. His mutation, the name of the mutation in the name of the defendants have been struck off, lordship. Thereafter, I suppose lordship, my petition is dismissed. Injunction is refused. Whether the respondents will be able to book the flat or to advertise for sale lordship, whether he can enter into an agreement for sale of the flats, no, until and unless the registration is done. So they will not face any irreparable loss and injury lordship. Rather, 3 days back, lordship, there are 28 numbers of the landowner who had given their land to the builder lordship. And they had 3 days back, they had attacked the office of the respondent builder lordship, and the builders were badly beaten. Because since 2014-15, the flats have not been handed over, lordship. Your lordship, please to consider if the flats should have been handed over within 3 years, lordship, the appellants would have enjoyed the flat.
All
He
right.
had the letter.
All right. Let me just read this averments.
Lordship, come to page 40. Para.
Yeah, just read. 14B, I think, no?
14A and B also.
Just read.
Page 40, lordship.
I have it. Please read.
That the petitioner plaintiff come to know that the sale deed dated 6/2/84 executed by Sri Hendranath Kumar in favor of the defendant number 2 and 3, and on the strength of the said deed, the name of the defendant number 2 and 3 omitted in the Jamabandi suit line. After going through the sale deed of the defendant 2 and 3, it came to the notice of the plaintiff petitioner that the said sale deed, it is a forged and manufactured one, and furthermore, on perusal of the same, it can be ascertained that the same is a forged copy of the sale deed of the plaintiff petitioner. Then lordship 14B, that in the respect of the forged and manufactured aforesaid sale deed 1, FIR dated was lodged by the petitioner plaintiff against the defendant number 2 and 3 before the officer in charge, Panbajar PS, being registered with case number 77. After the investigation, officer in charge has submitted a charge sheet, and on perusal of the charge sheet, it is stated that one force
Okay.
cell deed number so and
Sorry, I read it little fast. I've read it.
No,
Okay.
There is a vast difference.
No.
I am now old man. Sir.
No, nothing like that. It's
So,
all right.
No whisper in the.
See, when you are reading to ensure that I hear you and I understand. But when I was reading, I was just reading to understand it. So I went a little quicker because you know your facts. So you wanted to read it slowly for my benefit. But I went a little faster. Anyway, all right, Mr. Roy, I'm dictating the order. I have heard both of you enough. Now let me exercise my judicial mind.
Even
I don't know, whatever I think is going to be judicious in my perception, I will give it. You have grievances or you have grievances, both of you can take it
Lordship,
above.
my learned
but-
friend has placed Dhanpad case.
Yes.
In Dhanpad's case, para 6 Lordship,
Hmm.
the language is para 6 has the given by the apex court is that Lordship that the document or otherwise means Lordship if any document is filed that court is bound to consider para 4 Lordship. Dhanpad.
Yes.
Order 39. Please see.
Yes.
Order 39 rule Rule 1C proves that the temporary injunction may be granted where in any suit it is proved by the affidavit or
Or otherwise.
otherwise. Is otherwise, well, Lordship, if a petition is filed and when if document not given, but if subsequently the documents have been given, that comes under
Okay.
otherwise.
Yes.
And one judgment I have cited our on High Court division bench, Lordship, where the High Court held that division bench that if the sole purpose of
Bindeshwar Narayan.
yes, Lord.
Yes.
Para Lordship, may we please to tell para 12.
Bindeshwar Narayan, para 12.
Para 12. In the middle, your Lordship will find.
Okay.
Where the sole object in the middle now.
Yes.
Where the sole object of a suit is protection by means of the injunction. To withhold a temporary injunction may practically decide the cause in favor of the defendant without giving the plaintiff an opportunity to establish the truth of the case made by the plaintiff. Lordship. So this Lordship here and the present case Lordship may please to consider that almost all the landowners have filed cases against these builders. And in one of the other case, Lordship, the same court granted the injunction, Lordship, trial court, that your Lordship will find at page Lordship, it starts page 229. 229. Here the petitioner is Anita, who is the sister-in-law of the present appellant. Lordship, maybe this is the order on the injunction petition filed by the plaintiff, Lordship, last. Where is your honor? The trial court rejected my petition, but I filed appeal. Then the appellate court granted injunction, and Lordship may come to last page 237. 237. Hence, in excess. Lordship got it?
This is in respect of another property.
Another suit. Adjacent plot, Lordship. In this case, Lordship, Anita Day, who is the sister-in-law of the present appellant. Just like 28 numbers of the landowners are given, all they are come from poor family in long back. They had purchased 1 kata, 5 lecha, 10 lecha, and all of them have been cheated by the builder. Last one.
There are many landowners.
No, builder is same, Lordship. Builder is same.
Handful of landowners.
Builder is same.
My lord, who is creating this problem, my lord? Otherwise, building could have been completed. The registration could have been done.
And see the conduct after granting injunction by this honorable court, Lordship. They are proceeding day and night, Lordship. I have given the photo. They do not care.
I am not touching the contempt today.
Okay.
I am not touching the contempt.
It may be decided separate.
Because they have not filed their response in the court.
Yes.
Huh?
Affidavit filed.
So a contempt order did you just? I'm posting the contempt. I'm not closing the contempt. That will need to require adjudication. First, the contempt case is Lekhiba. Heard Mr. S.P. Roy, Learned Counsel, appearing on behalf of the petitioner with M.S.V. Rai, Learned Counsel for the petitioner. Also heard Mr. G. Rahul, no? Gautam Rahul, right? G. Rahul, Learned Counsel, appearing for the respondent, contemner. It is submitted that the contemner only one contemner.
Two, my lord.
The contemners have already filed their show cause reply pursuant to the notice issued from the contempt court.
We have filed reply on.
It is also submitted that the that the petitioner has also in the meantime filed their response, reply. Reply. It replied at 9. Acha, I said the reply. So this matter has to be fixed for hearing. Let the contempt matter be posted for hearing on such and such date. Now, সেই ওপৰৰখিনি same থাকিব, appellant হ'ব আৰু respondents না in the appeal. Ready? The present appeal under order 43, rule 1R of the CPC, read with section 151 of CPC, is presented against the order dated 12/6/2023, passed in Miss J case number 134 of 2018, arising out of TS number 63 of 2018, whereby the learned civil judge number 3 Kamrup M. Gauhati dismissed the application of the appellant filed under order 39, rules 1, 2, read with section 151 of CPC. The appellant contends that the appellant plaintiff had filed a suit being TS number 63 of 2018 for declaration, cancellation of deeds, recovery of possession, and permanent injunction, along with an application under Order 39, Rule 1 and 2 of the CPC. And the respondent's defendant had appeared and filed their written statement and written objection, and the suit is pending for disposal. It is contended that the appellant plaintiff is the owner of plot of measuring 2 katha, 1.5 lecha, covered by dag number 532 old stroke 344 new of KP Patta number 121 old 892 new of village Gota Nagar Moza Jalukbari in the district of Kamrup, Assam, and the respondent defendants, and they have entered into an agreement with the respondent defendants for developing the said plot of land to construct multi-storied building as a builder. Stop. Though as per the agreement, the building was to be completed within 36 and additional 6 months from the date of obtaining permission by the competent authority. However, the respondents defendants, after taking possession of the land, could not even obtain building permission from the authority for almost 3 years. It is further contended that the respondent defendant, by manufacturing forged sale deed showing that they have purchased the suit length from one Harendranath Kumar, obtained the permission, na? By showing this, they obtained the building permission, na? Obtain the building permission. In these premises, an injunction application was filed. No, despite the aforesaid forgery committed by the respondent defendants, the trial court, having rejected the injunction, sought the present first appeal order from the order of rejecting the injunction is being preferred. Mr. S. Roy submits that the injunction order is totally perverse, in as much as despite the trial court having found prima facie case in favor of the appellant plaintiff, refused to grant temporary injunction merely on the basis that third-party rights would be prejudiced. He submits that the trial court, while refusing the injunction, erred in law in taking into account the fact that the respondent defendants had forged the subject sale deed and has also submitted forged documents in respect of the suit length before the GMDA and GMC. He further submits that this court where is that order of this court, that inquiry? Just give me the page.
158.
158.
158.
কি বুলি লিখিলা? I have put so many flags. Now I am also getting confused.
Page 158.
No, that I have got 158. The other page I need is that amended plaint.
Yes.
That those paragraphs you were reading from the amended plaint.
Para 14A.
Page 40.
41.
51. He further submits that pursuant to the order of this court dated 18/5/2020 in I Criminal 472/2019, the Office of the Deputy Commissioner of Police Central District on 2/6/2020 submitted a report which clearly proves that the respondent defendants were not acting as a bona fide builder. He further submits that it is apparent from the conduct of the respondent defendants that they were conspiring with each other against the appellant right from the beginning to grab their land. Plaintiff is one. His plaintiff's land, his land. Stop. He further relies upon the decisions of this court in AIR 1984 Gauhati 86, 1981 1 GLR 231, and 1981 82. Oh, no, 231 to contend that
Lordship, on the basis of the fraudulent sale deed, builder obtained the planning permit and the working permit from GMD.
I will add it to it. To condemn that in exercise, while exercising the jurisdiction of granting interlocutory injunction, the court is to act upon the principle of preventing irreparable injury and to protect the suit property. He further submits, yes, please tell me.
Lordship, on the basis of the forced sale deed, the builder obtained the planning permit from the
He
GMD
further submits that on the basis of forged
sale deed
sale deed, the builder
obtained planning permit from the GMDA
from the. I have already said that.
and GMC.
I have already said that.
And on
Question two. Mr. Roy, it's already been said.
Claiming themselves is the owner of the land.
Mr. Roy, I have already said it.
Apply.
Per contra, Mr. G. Rahul, Gautam Rahul, submits that submits that the trial court that the trial court, having exercised its discretion and rejected the injunction, this court ought not interfere with the same, particularly when no case of perversity or patent error is made out. Correct? He further submits that the grounds relating to forgery was neither taken in the application for interim for temporary injunction, nor argued at the time of pressing the temporary injunction before the trial court. He further submits that he further submits no COPA. He relies upon the decision of this of the apex court in Wonder Limited in another versus Entox India P Limited, reported in 1990 supplementary SSC 727, to contend that appellate court ought not interfere with the discretion exercised by the trial court in rejecting interlocutory injunction by reappreciating the evidence on record. He further relies upon the decision of the division bench of this court in Dalpat Kumar and another versus Prahlad Singh and others, reported in 1992, 1 SSC 719, and the decision of the coordinate bench of this court in the case of Radhabari Tea Company versus Mridul Kumar Bhattacharjee, reported in 2010, volume 2 GLR at page 231, to contend that while the appellate court will not ordinarily substitute its own discretion in place of that of the trial court, yet where discretion is shown to have been exercised arbitrarily, capriciously, or by ignoring settled principles of law, regulating grant of or refusal of interlocutory injunction, the appellate court is bound to interfere. Stop. He accordingly submits that in the instant case, the order of the trial court indicates that the trial court has exercised its discretion in a judicial manner and hence ought not to be interfered with. I have given my prudent considerations to the arguments advanced by the learned counsels appearing for the contending parties and have perused the materials available on record. Order 43 CPC specifies the orders against which an appeal lies. Subrule R of Rule 1 of the said order provides that an appeal would lie against an order made under Rule 1, 2, 2A, 4 and 10 of Order 39 CPC respectively. The apex court in the case of Wanda Limited Supra have elaborately held the ambit, had elaborately considered the scope and ambit of the powers of the appellate court against grant or non-grant of interim injunction. Stop. The relevant paragraphs of the said judgment reads as under. Nine. $14 and $16. Huh? 9, 14, 16. In Ramakant Ambalal Chosky versus Harish Ambalal Chosky and others, reported in 2024 11 SSC 351, the apex court, while reiterating the principles held in Wonder Limited Supra, reiterated that interlocutory order passed by the trial court cannot be vacated by appellate court unless shown to be capricious, arbitrary, or perverse. The apex court also held that any order made in conscious violation of pleading and law is a perverse order. In short, a perverse verdict may probably be defined as one that is not only against weight of evidence but is altogether against evidence. The safest approach on perversity is classic approach on reasonable men's interference on facts. To him, if conclusion on facts in evidence made by court below is possible, there is no perversity. If not, finding is perverse. In other words, inadequacy of evidence or a different reading of evidence is not perversity. Relevant paragraph of the aforesaid judgment reads as under. $32 fra 19 কোড করবা 19 or পৰা একদম 36 37 In the present case, application, that interlocutory application is page 46. In the present case, in the application under Order 39, Rule 1 and 2 of the CPC, read with Section 151 of the CPC, it is specifically pleaded that the respondent defendants, after taking possession of the land, remained dormant and had done nothing to construct the building and obtained building permission from the authority only after 3 years, despite the petitioner plaintiff repeatedly requesting them to construct the building in accordance with the stipulated time agreed between the parties. Since despite the appellant plaintiff having visited the office of the defendant respondents to construct the building, to start the construction of the building, the respondent defendants having not taken any action whatsoever, the appellant plaintiff asked the respondent defendants to cancel the agreement and revoke the power of attorney. However, the respondent defendants, to their utter surprise, had given a photocopy of a building permission dated 22/9/17 and said that they are going to start the construction of building shortly. It is in this premises that no, one second. Accordingly, it is been pleaded that the defendant respondents were not acting as a bona fide builder and committed fraud and is trying to grab the land of the builder, of the appellant plaintiff secretly. The defendant respondents filed their where is yours? Filed their written objections against the interlocutory against the temporary injunction application under Order 39, rebutting the averments made therein. The trial court, upon considering the matter and after hearing the parties, though found a prima facie case in favor of the plaintiff appellant, however, rejected the interim injunction, temporary injunction sought for on the ground that since the developer, defendant, respondent have already invested a huge amount of resources for development of the suit land, after the appellant plaintiff handed over the same to them for the purpose of construction of flats, and having also entered into agreements with intending buyers, any delay or restraining the development of the project would not only cause loss and inconvenience to the respondent defendants, but also to the intending buyers whose investments are at stake in the project. Relevant paragraph of the impugned non-grant of the temporary injunction order dated 12/6/2023 reads as under quote unquote. Page 71, A to A. Page 71. Equivalent. यहाँ पे Okay. I think, let him type out the entire facts and this part, concluding part, let me rethink and give it. All right.
Only.
I think more or less your submissions have already been covered. I have, and the case laws that both parties have cited is also already given. Yes.
Lordship, only pleased to peruse the averments made in para 2 of the plaint, where page 47, where it is stated that the statements made in the plaint.
Okay, I remember you have said it. I'll put it. I remember you've said that all the statements of the plaint is part of. Okay. I will, let me think of it.
No, your
Okay.
Lordship.
So you won't get this order today.
Okay.
One vital aspect, my lord, we have repeatedly stated in the written objection and the written statement also, though he had promised to give us 2 kathas of land, but as per the revenue record, it was only 1 katha.
Because
So
for
those
1
things
katha,
were
your
also-
Lordship,
those facts were
fraudulent
also
sale
before
deed
the
was,
trial
it is
court.
mentioned in the Jamabandi. For 1
Was
katha, they have
In the promise was for 2 katha something, my lord, and again in the.
Miss Rai is telling Mr. Roy to say that it is for the trial court to decide.
Yes.
Those facts were available before the trial.
All right.
While
all right,
refusing
all
to
right,
grant.
all right. Let me think.
Because lot of things have been said about our conduct, their conduct is also.
Their
doubtful.
conduct is heinous. That's why beaten.
Okay, let me do one thing. let him type out the order. I'll post this matter on Thursday. Let it come before, because let me see what happens. So even, but obviously by then your order will be ready. It is only so that to pronounce it in the court, because I have not pronounced. I have not yet decided. I have given the skeleton. Let me think once again. And whatever happens on Thursday, I'll pronounce. So,
So, my lord, only my one prayer. I will be allowed to submit tomorrow two judgments.
on what?
Suppression of facts and fraudulent.
No.
Fraud.
Hearing is completed, Mr. Roy.
Supreme
Don't
Court
burden
says
me
that
now
if
more.
there is a fraud.
No. If there is a fraud on what?
If there is a fraud and any party has not approached the court to clean hand, such type of petitions should
That
be
is for
sought.
226.
226.
That is 226.
No.
That is 226.
It arises that those judgments are of civil CPC.
Principles
If I am allowed, tomorrow I'll.
Principles of.
That those are equity principles. He's right. Anyway, we are not on that right now. Thursday rakho na Monday rakho?
Can it be on
Monday?
Thursday, I also have some.
Okay, Monday কৰি দিয়া। মই এইটো তুমি এইখিনি বেলেগ কৰি দিবা আৰু এইটো heard in part কৰি Monday কৰি থৈ দিয়া।
60.
Give those decision tomorrow, Miss Rai. If you give it tomorrow, I will take it. Otherwise, I will not take it. You give it to the court master. With a copy to Mr. Rahul. But I think, Miss Rai, those decisions are on equity.
Equity lordship, a person who has fraudulently prepared.
All right.